My please, Lordship.
Yes.
Lordship, I beg to mention item number 3, Lordship. Matter may be adjourned. Yes, Lordship, the arguing counsel, Dr. B.V. Todi, could not appear due to some personal difficulties, Lordship. Matter may be fixed on 19/6.
In this case, I am appearing for the respondent, Lordship. The matter is of 2018. And the issue has already been decided by the Honorable Court.
Let us see when it reaches. Yes.
I would like to mention item number 40.
40.
40. My lord, for the matter is listed after motion for the first time. So, government will file their affidavit after some time, my lord.
Item number
40.
14.
40, my lord.
Yes, but since it has come up after so long, let us see why it has come. Why are you making a mention?
Only, my lord, actually, that 40, my lord. 40.
40.
40.
Yes.
Matter is listed after for the first time motion, my lord.
Oh, it's a
Motion after-
25 matter.
Yes, my lord. That affidavit is not filed.
Government is there.
I have informed the government, my lord. I have informed the government.
Mr. Sharma, let the forest be there because they're going to seek time. At least some effective orders can be passed.
Hello, my lord.
If you make a mention and go, it will be only said as prayed. I cannot say that they are seeking time to file something. You don't want this case to be proceeded,
Yes, my lord.
huh?
After some time, yeah.
So it will be called.
Hmm.
You wait.
Wait.
If you have some difficulty, ask your junior to be here.
Yes, yes.
Yes.
Okay. Obliged, my lord.
Item 45, we have filed an additional affidavit today, Lordship. That may be called for.
May I please, Lordship? Lordship, I beg to mention item 21, Lordship.
Yes.
Lordship, matter may be taken up in the next week, Lordship.
Why?
Lordship, my senior MSP Chakrabarti is out of town, Lordship. Due to some
Have you
personal-
informed the other side?
Lordship, I informed the government.
Government, finance,
Yes.
as prayed for by Miss MS
K. Khan.
K. Khan, learned counsel appearing for the petitioner on the ground that MS P. Chakraborty, learned arguing counsel, is
Out of town, Lordship.
out of,
Town, Lordship.
is out of station, with consent from the other side, relist after 2 weeks on a date to be fixed by the registry.
Much obliged.
Wait, please, Lordship. Lordship, with the consent of the other side, I beg to mention item number 13.
Yes,
Lordship 13.
yes.
We have to file an affidavit in opposition in the matter. Lordship,
I
we
think
require some-
steps is also to be taken. Let's see. Let the matter be called.
Lordship, Lordship, service is complete in the matter.
I am the petitioner, Lordship, on behalf of my senior Mr. NNB Chaudhary.
I think some steps is required.
We've taken your Lordship, the steps.
Let me see. I'll accommodate you. Is there any difficulty for you all to wait?
Actually, we have several matters.
Yes.
May I please, Lordship? Lordship, I beg to mention item number 11, Lordship, on behalf of Mr. S. Samaria, Lordship.
Yes.
He has some difficulty, Lordship, today. I am pairing for short accommodation, Lord.
As prayed for by Mr.
MM Zaman, Lord.
MM Jaman, learned counsel appearing for the petitioner with consent from the other side, on the ground that Mr. C. S. Chamaria, learned arguing counsel, is having
Some personal.
personal difficulty today, which is not opposed by the other side, relist after 2 weeks on a date to be fixed by the registry.
Interim order is there, Lord.
Interim, if any, shall be date dedocated. After 1 week, date on such and such date.
Lordship, can it be after 2 weeks, Lord?
No. If you don't want the interim to be extended, certainly I can fix it after 4 weeks also if you want.
Lordship, 1 week.
If you want the interim to be extended, then only 2 weeks. Only the date on which, yes.
Deeply obliged, Lordship.
May I please, Lordship? I beg to mention item number 10, Lordship.
10,
Yes, Lordship.
eviction. Yes, what do you want?
Lordship, matter may be taken after 2 weeks, Lordship, that's because my senior health is not well, Lordship.
Consent
I have taken consent.
as prayed for by Mr.
A. Hussain.
A. Hussain, learned counsel appearing for the petitioner with consent from the other side, relist after 2 weeks on a date to be fixed by the registry.
Deeply obliged.
May it please your lordships. My lord, in item number 19, lordships, we have filed our power day before yesterday only, madam.
Yes.
Taking the consent of the other side, lordships, can it be fixed after 2 weeks, madam?
Mr.
PK Garodia, my lord.
P.K. Garodia, learned counsel appearing
For the
for
petitioner.
huh?
For the petitioner.
For the petitioner submits that there has been a change of counsel and he has been recently engaged and he has accordingly filed his power
Day before yes.
day before yesterday. And therefore with consent from the other side seeks a short accommodation.
Got it.
Prayer is allowed when
Lordships, can a date be fixed, my lord?
released on such and such date. Yes.
My lord. After vacation. 16,
Yes,
17.
next.
Yeah, please, Your Lordship. I beg to mention item number 12, Lordship.
Yes.
Due mention of the other side, I'm for a petition, Lordship. In this time, we need to sometime for filing reply affidavit.
You are Mr.
We go, Lordship.
Heard Mr. D. Gogoi, learned counsel appearing for the petitioner.
Yes, Lordship.
Seeks 2 weeks' time to file rejoinder against the affidavit in opposition filed on behalf of the state respondent.
Yes.
Prayer is allowed, released after 2 weeks on a date to be fixed by the registry. Yes, Mr. Sahaiwala.
Yeah,
My lord,
Interim, if any, shall continue to the
Item
next.
number 6 to 9, my lord, they have become infractuous, my lord. Their charge sheet and some final reports has been filed. So these 4 items may become
6 to
infractuous.
9.
6 to 9.
6 to 9. Heard Mr. G.N. Sahaiwala, learned senior counsel assisted by
HK Sharma.
Mr. H.K. Sharma, learned counsel for the petitioner. Also heard Mr. J. Bokolia, learned government counsel. Learned government counsel for the state respondent. Mr. G.N. Sahaiwala, learned senior counsel, submits that the writ petitions in the meantime have become infructuous
Because, my lord, final report and charge sheets have been filed.
as the final report and the charge sheet, as the charge sheet and the final report.
Not from, in some cases, final reports, my lord.
As the final report and in some cases charge sheet
Yes.
has also been filed, in view of the aforesaid endorsement made by the learned senior counsel, nothing survives for adjudication in the instant matters. Accordingly, the writ petition stands closed on, dismissed on being infractious. You wanted to withdraw or what? No. Was that your prayer?
It may close, my lord.
Lordship, one more pair, my lord, in respect of the item number 51, and for the respondent contempt, my lord, we are newly engaged, Lordship. My lord, I have taken consent from the other side, my lord, 2 weeks time may be given for filing affidavit. For the first time we are here.
Mr.
D. Gogoi, Lordship.
D. Gogoi, learned counsel appearing for the respondent,
Lordship.
stroke contempt number
1 and 2.
1 and 2 seeks 2 weeks' time to file reply affidavit in the matter. Prayer is not opposed, released after 2 weeks and a date to be fixed by the registry.
Deeply obliged.
Yes, Mr. Deka.
My lord,
Yes.
it's by Mr. Chaudhary, my lord, he's on legs in court 2. Otherwise, my lord, 67, page 67.
No, I'm just checking something else. This is not that Sonari tea family.
No, my lord.
Seeing the surname, I was a bit confused. That's why I'm asking. All right, you want Passover for the time being?
Yes. Obliged.
Yes, Mr. Nath,
My lord, the issue involved in this case is,
refund
I-
of excess amount.
yes, I paid. My lord.
Yes, Mr. Doctor, anything?
No, not excess amount, my lord, sir. No, actually what has happened, I applied for loan and they have sanctioned 8 crores. For 8 crore loans, the processing fees was 8,42,000. But they gave me only 1 crore, the rest of the balance they did not give me. So I made a prayer to them, you have taken front for 1 crore, for 8 crores, but give me 8 crores, rest you return me back, that's the issue. For which, my lord, what happened?
You have taken loan from whom?
IDBI Bank, my lord. IDBI Bank. Now only one thing, my lord, today. Last occasion he produced the records here.
Huh?
The records, last occasion he produced on twice. But whether if the record is required in this case, in that case, my lord, today probably, if Lordship takes the matter, I'll argue.
The records are there.
Records were there, my lord, because I It was sent it there. back, but today morning I received it back, my lord. But then, my lord, it will need some time. My
Then
prayer,
we'll have it on another day.
no, my prayer, let it be, my lord, admitted and fixed for hearing immediately after the vacation. My lord. That's what I want to short it, my lord. That's
Right. Heard Mr. M. Nath, learned senior counsel, assisted by Mr.
A. Bhattacharya.
A. Bhattacharya, learned counsel for the petitioner. Also heard Mr. M. Datta, learned counsel appearing for the respondent ban. The matter requires full-fledged hearing. Admit no formal notice as parties are, as respondents are duly represented by their respective counsels. It appears that the records was called earlier.
It was there, my lord. In fact, I produced it also.
It appears that the records, the relevant records pertaining to the issue in hand is also essential and necessary for effective adjudication of the matter. Let the records be also made available on the next date of hearing, on the next date of listing. List for hearing when?
29th, my lord, of July.
Yes, 29th July. It is
In August. Give a date in August.
August. Yes,
Or
my
such and
lord.
such date.
My lord. No.
Yes.
Then make it on 12th August. It's a Tuesday, my lord.
All right.
Yes, hearing.
Yeah.
Published, my lord.
Yes, service tax. You wanted some accommodation
Yes,
here.
Lordship, matter
Yes.
fixed on 19/6, Lordship.
All right.
I have no objection, lordship.
Uh,
Lordship, every time they are taking time.
No, lordship.
The issue has already been decided by this honorable court. They have challenged the omission of
What is the issue?
issue, lordship. Here they have challenged section 100 of because lordship in 2017 GST Act was promulgated and chapter 5 was omitted. Their contention is that the matter relating to earlier period, so this is not covered by this. And this honorable court has already decided this issue.
All right, let her have her senior. I'll 19th of date.
Actually, fixed it may be fixed because
96,
yes.
Lordship.
19 will be difficult. MS
R. Jugli on behalf of Dr. BP
R.
Jugli
Jubilee Learned Counsel appearing
on behalf
on
of
behalf of Mr. On behalf of Dr. BP Todi submits that no, don't say that. So and so submits that the leading counsel for the petitioner, Ms. Dr. So and so, is what happened? Why is he not here? Personal difficulty or medical grounds?
medical grounds, Lordship.
Is indisposed and accordingly seeks a short accommodation. Mr. Cal, Learned Standing Counsel, Standing Counsel GST, submits that repeatedly the time has been sought on behalf of the petitioner, despite the issue involved in this writ petition is covered by a judgment
of this honorable court reported in.
by a judgment of this coordinate bench.
Yes, sir.
By a judgment of the coordinate bench of this court in the case of
Reported in 2018 for GLT
2018
for
for
GLT.
GLT
is 910.
910. Party naam to likhe digo. Please ask a junior to just give the citation.
Yes,
Huh?
Lakshmi Narayan Sahu.
Lakshmi Narayan sir.
What's the union of law?
Be it be in view of the medical in view of the adjournment being sought on medical ground of the leading counsel, this matter is fixed is refixed on give a date on such and such date
Can be
on which however it is made clear that further adjournment shall be granted to the petitioner.
Lordship cannot be on 26, Lordship, 25. Much obliged.
Ma'am, please allow.
Yes.
My lord, this is regarding a public function that was proposed by the petitioner association, my lord. And permission was granted by the district magistrate wide annexer at page 32.
What is your right? What is your right? You wanted to hold a public function
Yes.
in a ground.
Yes,
That's a public ground,
is a railway ground.
railway ground.
Yes.
They initially gave permission and they
Then
refused.
we altered our position. We deposited the security money. Everything was done.
That is not returned.
Nothing has been returned.
Why
And
not
in the
returning?
course of,
Oh, I'm not sure about that, but if they make an application, it will be returned, my lord.
Yes,
To make
where is
things
the
clear,
representation that you have submitted the deposit which is still lying with them and have not been returned, where is that pleading? Where is that pleading?
My lord, it was deposited.
Where is it?
Page 11. Oh, paragraph 11. My lord, that paragraph 7, page 10.
Yes.
That the respondent number 4, divisional railway manager, Railway, Rangya, immediately on receipt the aforesaid amount of rupees 32,000 being the license
Yes,
fee.
where have you, they said that they have not returned this back?
They have not returned, my lord.
Where have you said? Where have you said, Mr. Counsel?
Yes, I have understood.
It has to be there in your pleadings. We cannot
it-
assume something because you, what is your locus? That's a railway ground. They may have given for some reason, they may have refused. Now, just because they refuse, you cannot come before the writ
Lord,
court.
may kindly permit me to submit. My lord, we applied bona fide, we applied to the deputy commissioner
Very well.
for grant of permission. Accordingly, permission was granted. Based on that promise,
Where is your right? Show me your right. What is your legal right? What is your legal right that you are entitled to hold this function in the railway ground?
yes.
Where is that right?
Yeah, that
And where you are saying that you've been prejudiced. Prejudiced because your security deposit has, whatever you have paid has not been returned. Where is
nothing was
the
returned.
averment?
Nothing was.
Where is the averment, Mr. Counsel?
My lord, at the time of filing this petition, we called in question the action taken by the district administration regarding the cancellation of the permission that was granted. And at that moment, this very averment was not there.
You have said it
But
is in gross violation of all laws, rules, and regulation.
Yes, my lord.
Please show me what are these law.
We were not hard before taking that action. Whatever action was taken.
Where is your right? Show me your right first. Show me your right first.
My lord, 32, page 32. Page 32 is the.
Yes.
This is the order whereby we are given permission
Very well.
to hold it particular function in a particular place. And my lord, based on this, Annexure E, the railway department, they submitted their cost rate. Whatever cost was involved, that was informed to us by Annexure E.
Yes.
Then Annexure F. Annexure F was given when the money was deposited.
And is only deposited temporary land
Yes,
license
F.
fee. Henceforth is allowed to celebrate.
Yes,
So
and yes, thereafter Annexure Z, my lord, these are the invitation letter issued by our association to all the aspirants. to
where
attend
is the
function.
cancellation now?
Now cancellation comes at page 46.
Yes. Yes.
Lordship, in between you.
Because of law and order situation, it has been cancelled.
Yes, based on that only, it was
Yes.
purportedly cancelled on that basis of that. And my lord, what happened?
I don't
That is-
see any case, Mr. Counsel.
Yes. What I did, I called in question the action taken by the administration, whether it was correct at that point of time or not. But it has, by the lapse of time, it pertains to year 2018. So by this time, some portion of our prayer has become infructuous. So far the other things are concerned, because of that cancellation, many things happen. Those were given in the photographs at Annexure H. At
What
page
is-
43.
What is that what do you want today?
Now, my lord, since that time cannot be brought back, that situation cannot be brought back, at least whatever wrong was done, that may be remedied by the honorable
How?
court.
By giving you compensation.
By way, even that prayer is also there, that will look into by your lordship. But so far, the money deposited by That has not been deposited. They filed their affidavit. They did not say anything.
Where in your petition you have said that this has not been given back to you after the
My
cancellation?
lord, that was not our prayer at the time of filing the writ petition.
Where is the onus on the railway authorities to then on their own say this? Suppose they have returned it.
There was
How
no,
can you presume all this? First of all, you don't make the necessary pleadings, and then you expect that this court to get into all these controversial issues? Yes, Mr. Sharma, what is your stand?
So far as returning the money is concerned, my lord, at the time of filing the writ petition, that question did not arise at all. my lord.
Yes.
Yes.
Their prayer in the writ petition was that they should be allowed to hold the meeting.
yes.
Now, I don't know whether it has been returned or not, but to return the money, there has to be an application, whether they have done that, my lord. If they
yes.
have filed an application,
That is not, the writ petition doesn't say anything.
doesn't say anything, my lord. If they make an application, my lord, the railway authority will definitely consider and pass an appropriate order. If it is refundable, they will refund it. If it's not refundable, they can challenge the decision before.
What about the maintainability of the writ petition?
It's not at all maintainable.
Why?
So far as railway is concerned, my lord, it's not maintainable against the railway because of the fact that the railway had neither given the permission nor cancelled it, my lord.
After the cancellation order at page 46, any representation filed?
Two railways, no, my lord.
Thereafter,
Which is
no
allowed-
representation, one FIR was lodged.
Which is
My lord,
allowed-
one FIR, at that FIR comes at,
So
now-
directly approach the court without a demand.
one FIR was lodged at page 52, lordship may
I'm
kindly
not
take note of
concerned with
that.
the FIR. Any representation made before approaching this court?
No, it's not them.
Any approach, because you see what you're seeking is a mandamus.
Yes.
I don't think this court needs to emphasize the settled position of law that if one seeks mandamus, there has to be first a demand. Upon refusal, one can come for mandamus. Correct?
Absolutely.
Where have you said that you have given a representation for considering, for
yes.
returning? Where are those?
Body of the petition, it is there. In the body of the petition at paragraph 21, it is there that approach the
That's a
respondent
general.
authority.
That is a general.
Yeah.
That is general. That is
So
only in
far,
general.
record is concerned, nothing was brought on record regarding the representation so made. But thing is that we called in question the very action taken by the responding
Sorry.
authority.
No cases made out. However, I can, while dismissing, I may observe that in the event any representation is made for returning the amount which was paid at the time of booking, the authorities shall look into it. With that, I can make that
Yes, sir.
observation, but otherwise I'm dismissing it. No cases made out. Yes. Heard, Mr.
R. Sharma,
Dr. R. Sharma.
Mr. R. Sharma.
Mr. R. Sharma, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned
See railway, my lord.
standing counsel, railway. And Mr. B. G. Bokolia, learned government counsel, learned counsel for the state respondent. Anybody else? Mr. Chetia, are you there? By way of this writ petition under Article 226 of the Constitution of India, the writ petitioner is assailing the order dated 29/1/2018 issued by the Additional District Magistrate Bongaigaon, whereby the said authority has illegally don't say illegally, whereby the said authority has cancelled the permission earlier granted to the petitioner association for holding the 508th birth anniversary of Vir Surja Viswa Mahavir Association at Dangtol Railway Institute Playground on 30th and 31st January 2018 in gross violation. Full stop. The brief facts of the case is that that the petitioner association, in order to celebrate the 508th birth anniversary of Bir Surja Vishwa Mahavir Chilarai and the 20th annual convention of the association, at Dangtol Railway Institute Playground at Bongaigaon, approached the railway authorities by way of an application dated 2010-2017, seeking permission from the said railway authority to hold the program at the said premises, at the subject premises on 30th and 31st January 2018. Tumikola Railway Authority within bracket Didiba, respondent number 4. The respondent number 4 by letter dated 4/1/2018 requested the petitioner association to collect the NOC from the Deputy Commissioner Bongaigaon within bracket respondent number 2 and to submit the same with the respondent number 4 for taking further course of action. Stop. Accordingly, the petitioner association approached the respondent number 2 by application dated 5/1/2018, whereafter the respondent number 2 by order dated 9/1/2018 accorded permission / NOC to the petitioner association for holding the program as prayed for. It is the specific case of the petitioner association that after obtaining the permission / NOC, they have deposited the requisite temporary land license fee, security deposit, etc., amounting to rupees 32,974 in terms of the letter dated 16/1/2018 received from the respondent number 4. However, the stop. Pursuant to which the respondent number 4 by letter dated 19/1/2018 granted permission to the petitioner association for celebrating and for holding the program as prayed for. It is the specific case of the petitioner that after the petitioner association prepared invitation letters, etc., suddenly the respondent number 2, Deputy Commissioner,
Yes.
the 2 by letter dated by impugn letter dated 29/1/2018, cancelled the permission granted to the petitioner association. Situated thus, the present writ petition has been filed. Mr. Suenzo Bokolia, learned counsel for the petitioner, submits that due to efflux of time, the prayer made in this writ petition as regards cancellation of the permission granted earlier and directing the respondent authorities to permit the petitioner association to hold the said program on the scheduled date has become infructuous. However, he submits that since the respondent authorities have in a most illegal manner cancel the permission granted to the petitioner association, that too without affording any opportunity of hearing, the petitioner association is liable to be compensated in law. He further submits that the deposits made as per the request of the respondent number 4 for facilitating the issue of the for facilitating the grant of the permission, though the permission has been cancelled, is not returned to them. Per contra, Mr. B. Sharma, learned standing counsel, Railway, submits that the state authorities, having cancelled the permission due to apprehension of law and order situation, no interference from this court in exercise under Article 226 of the Constitution of India is called for. He further submits that it is nowhere mentioned, it is nowhere pleaded in the writ petition as whether the deposits made by the petitioner association at the time of seeking permission has been returned or not returned. Moreover, there is no such representation filed by the petitioner for returning the aforesaid deposits. First one, heard, peruse, correct. Apt to refer to the prayers made in this writ petition at the outset, A to A, page 12, which reads as under. It appears that as per the request made by the petitioner association, the respondent number 2 by order dated 9/1/2018 accorded permission to the petitioner association to holding the program as prayed for. The order dated so and so reads as hereunder, page 32, A to A. Reading of the aforesaid order, it is clear that after considering the report of the Superintendent of Police Bongaigaon, the permission for holding the program was accorded, however, subject to the following terms and conditions. It further appears that it is also mentioned, it is emphatically mentioned in the order that the above permission can be withdrawn, is liable to be withdrawn at any time without assigning any reason thereof, if situation so demand. It appears that thereafter, temporary land license fee as asked by the railway authorities has also been deposited by the petitioner. However, by the order dated 29/1/2018, the approval accorded by the respondent number 2 was cancelled. The order dated 29/1/2018 reads as under A28, page 46. The reading of the aforesaid order, it is clear that upon receipt of an complaint, an inquiry was conducted by the jurisdictional executive magistrate and the report indicates and the inquiry report submitted thereafter indicates that there is every possibility of breach of peace and disturbance of public tranquility if the program as prayed for is allowed to be held at the railway playground. It appears that after considering the aforesaid report received from the jurisdictional executive magistrate, the respondent number 2 cancelled the permission granted earlier. The apt to prayers. The aforesaid in the aforesaid writ petition, it appears that the petitioner, after the cancellation order, without making any representation, has directly approached before this court by filing the instant writ petition. It is well settled that before seeking mandamus, there has to be first the demand, and only upon refusal, a writ of mandamus can be invoked. That apart, it appears that while issuing the permission to the petitioner association for holding the program as prayed for at the Railway Institute playground, it was made clear that the same can be cancelled at any time without assigning any reasons. The petitioner association being fully aware of the aforesaid conditions, upon the permission so granted being cancelled based on an inquiry, cannot complain violation of natural justice, inasmuch as there is no legal right of the petitioner violated. It further appears that the permission granted earlier being cancelled in terms of the report, which indicates apprehension of breach of peace and disturbance of public tranquility. If the program as paid for is allowed to be held, comma, I am of the firm view that the impugned cancellation of the permission cannot be interfered with, as the same is in the larger public interest. That being so, the writ petition fails. However, it is also made clear, no, it further appears that during the course of hearing, Mr. So-and-so, learned counsel for the petitioner, submitted that the deposits made by the petitioner association at the time of at the time of issuance of the permission, since has not been returned, the same ought to be directed to be returned, comma. However, no such averment as regards non-returning of the deposits is made in the writ petition. Since this court does not find any merit of this writ petition, the writ petition stands dismissed. It is needless to be clarified that in the event the petitioner association makes an representation before the railway authorities to return the deposits made by the petitioner association at the time of the issuance of the permission, comma, the railway respondents are at liberty to consider the same in accordance with law. This case is dismissed. Affidavit has been filed.
Yes, Lordship.
Yes, Mr. Roy Chaudhary.
The petitioner was living near in Hojai as a landless person, my lord. He in occupation of 10 letters of land near Paschim Dharnidhar Pathor, where, my lord, it is near Padampupuri Grazing Reserve. My lord, there were some portion of land, other people's were, after de-reserve, you were allotted lands. And those documents were placed before them. And I was paying Toji, and I was in occupation of 10 letters of land. So there was an apprehension, they will throw me out. I approached this court, and my lord, and 22-380.
Affidavit has been filed. You don't want to file any reply?
My lord, only thing at this moment is this, my lord, that the situation is as such, because they have filed an affidavit stating that a person occupying government land does not have any legal right. That concept is wrong, man. Because earlier, this affidavit was filed in 22.
All right, the matter then we'll post it for hearing.
Well,
We'll need some hearing.
well,
Heard Mr. P.K. Roy Chaudhary, learned counsel appearing for the petitioner. Also heard Mr. A. Sharma, learned additional senior government advocate for the state respondent and borderland.
Yes, sir.
Learned standing counsel revenue and disaster management. Mr. Sharma submits that the affidavit in opposition on behalf of the state respondent has been filed on
10/7/22.
on
19/7/20.
19/7/2022. It appears that no, Mr. Roy Chaudhary submits that no rejoinder is required against the aforesaid affidavit in opposition. It appears that the matter requires full-fledged hearing. Admit no formal notice as parties as respondents are duly represented by their respective counsels. Post for hearing on any date in the month of August to be fixed by the registry.
The interim order passed on 22/3/18.
Interim order passed earlier shall continue till the next date of hearing.
Obliged.
এটা তো ভুল করে না 13 টাইম লয়ে আসতে নাই
Lordship, as per the last office note, service is complete and it was late for admission.
In the morning, some time was being sought, right?
Yes, Lordship, I'm for respondent number 4 in the matter. So, Lordship, we need some more time to file an affidavit in opposition.
As prayed for by MS
P. Agarwala.
P. Agarwala, Learned Counsel appearing for respondent number
4.
4. Relist after 3 weeks
3
on a
weeks.
date to be fixed by the registry to enable the said respondent file return in the matter.
May I pray, my lord? In this case, we have written to the department. The department is seeking for further 2 weeks' time to file affidavit.
Mr. A. Bhattacharjee, Learned
Standing
Standing Council, Revenue and Disaster Management submit that the instructions are still awaited and accordingly seeks a short accommodation in the matter. Prayer is not opposed. Relist after 2 weeks.
3 weeks.
2 weeks
My lord.
on a date to be fixed by the registry.
Obliged.
Contractual bill.
My lord.
Since when?
My lord, page 17, my lord. Some part payment has been made, my lord, but remaining balance amount has not been paid. Page 17, my lord.
Page 17.
My lord. Annexure F.
The total amount is 24 lakhs 2,000 something.
That is the balance
The
amount.
balance amount will be paid as soon as government releases the fund. And this was in 2019.
My lord.
So Chetia,
Yes, my lord. After 19, my lord, matter has come up now. I have to take instruction. my-
this is not the concern
Yes,
of
yes,
this
ma'am.
court.
Yes, ma'am. Yes, ma'am. Yes, yes.
Now,
ma'am.
if the matters are not coming before this court, doesn't mean that government will sit silently over the contractual bill of the petitioners.
My lord,
When
what?
it is admitted due, nothing doing, I am disposing it off. 3 months, you make the payments. Huh?
My lord, in 2019, my lord, we have received an instruction that they are saying that for according revised administrative proposal, my lord, proposal will be submitted. Whether that has been done or payment has been.
I am not concerned with all that.
Yes.
Your, this letter
Yes.
is very clear. Office of Chairman Biswanath Chariali Municipal
Yes,
Board,
ma'am.
that they are entitled
Yes, ma'am.
and they are waiting for fund.
Thereafter also we have.
Who is appearing for the municipal board?
Municipal board, I am not paying, my lord. I am paying for the DX, my lord.
I'm posting this matter on next Tuesday.
Next, I will, in the meantime, I will.
Aji, Wednesday, na? Monday. You have it by Monday?
This Monday, my lord. Monday will be some difficult.
Why difficulty?
7 days, man.
No. You just obtain the instruction. You are for the government.
Yes, ma'am.
Yes. I only need a time schedule.
Yes, ma'am.
You cannot keep these matters hanging like this.
Yes, ma'am. Okay.
The document at page 17 is very clear.
Yes, ma'am. Thereafter also they are saying.
And smart payments have already been made.
Yes, ma'am.
You cannot
By-
keep
by-
the
by Monday.
petitioner hanging
Yes,
from
ma'am.
2019 and not make payments.
Yes. I'll take instruction.
This is not to be done. Heard Mr. R. Sharma, Learned Counsel for the petitioner, and also heard Mr. M. Chetia, Learned State Counsel. It appears that the part outstanding balance amount of rupees 24,02,939.90 is pending release due to non-release of fund from the government. Mr. Chetia, so and so shall apprise the court as within this as the time frame within which the aforesaid fund shall be released to the municipal board in order to correct,
Yes.
in order to make
Make it.
the payments to the petitioner. Relist, yes. Monday,
16,
Monday, 17,
17 my lord, or 18 my lord, 17 some my lord,
16 then,
16 my lord.
otherwise 20,
No.
20 would be better, my lord.
20, all right.
All right.
But you get positive
Yes, yes,
instruction,
my
Mr.
lord.
Chetia.
Yes, my lord.
Yes.
Matter was last listed in November 2020. Well, the order was passed during COVID time, my lord. As per the last order, I need to file an additional
Additional?
affidavit, my lord. This is regarding setting
How
up
much time do you need?
2 weeks time, my lord.
As prayed for by Mr. B. Chakraborty, learned counsel appearing for the petitioner relist after 2 weeks on a date to be fixed by the registry to enable the petitioner file the additional affidavit as directed,
Directed by order dated
as directed earlier by this court by order dated
12/11/2020. 11/11/2020.
12/11/2020. I said after how many weeks and all that? All right. This also after 20, it has come.
Yes, my lord.
First time after notice.
Yes, my lord. Order dated 22/12/2020. Order dated, my lord, 22/12.
Yes, I have that order.
Yes, my lord. Yes, my lord.
None appears for the petitioner on call.
Private dispute in my lord. This is a private dispute, my lord.
Mr. M. Chetia, learned so and so is present. It appears that this matter has been listed for the first time after issuance of notice on 22/12/2020. Let registry intimate the petitioner and or the learned counsels appearing for the petitioner as regards the next date of listing, either by WhatsApp or email. Relist on such and such date, give a date. Yes, Ms. Kope.
My lord, matter pertains to dispute redressal scheme, lordship.
What scheme?
Dispute resolution scheme, lordship. What happened?
Dispute redressal.
Sabka Viswas lordship scheme
No.
for those, they give the benefit like you have to pay only the tax, 50% of tax, and your interest and penalties waived off. That sort of scheme. Actually, after the coming of GST, of 2 years of coming of GST, they in 2019, this scheme was brought into effect.
This matter otherwise is ready for hearing. Pleadings are complete.
Yes.
But then this will take some time, I think, Mr. Kayal.
Yes, Lordship, it will take some.
So I'll admit it and post it for hearing. Heard MS ML Gopi, right?
Yes, yes.
Learned counsel appearing for the petitioner. Also heard Mr. KC Kale, learned abstaining counsel, GST. It appears that the pleadings are completed. The matter requires full-fledged hearing. Admit no formal notice as respondents are represented through their one respondent.
No, there are more than one.
Okay. All you are
All
representing all
Yes, Lord.
through the is duly represented. Simply say that. And list for hearing in the month of September.
My lord, but only one thing, this similar matters has all been remanded back that the department will consider and give an order.
You wanted that kind of an order.
If he agrees, otherwise then we'll have to do the hearing.
Lordship, in the meantime, Supreme Court has passed an order. And the scheme is there. If there is any amendment that is amounts to interfere with the scheme, that is not permissible.
So, are you agreeable to that?
No.
No, you're not. No.
Then
In
it may-
September.
Lordship.
Then it's with. My favorite.
May I please, Lordship, in this case, pleadings are conflict minor, so I pray for matter may come on any hearing date minor after vacation minor.
It's a huge matter.
Yeah.
What is the issue? Settlement of fishery.
Yes,
Settlement of fishery law.
Admit it then.
Fix it for you.
Heard, Mr.
Reason meeting.
So and so laird counsel for the petitioner also heard.
Miss A Talukdar for respond number 8.
A Talukdar for respondent number 8, M Chettial and State Council. And your name. Huh? L. Izo. Huh? Laird counsel appearing on behalf of C. Bottler. C. Bottler and Standing Council. Respondent number 4. Full fledged hearing, admit, no formal notice. List for hearing in the month of
July minor.
not July, September, on any date to be fixed by the registry.
Much obliged.
Yes. Matters come after a long time. No, this was already there. None appears for the petitioner on call. MSJ Gogoi.
Yes.
Laird counsel for the petitioner, for the respondent.
Water resource
The
laws.
respondent Water Resources Department is
Lordship,
present.
these are FMP related matters and similar matters were taken by court for disposal, Lordship. If Lordship may taken this matter.
Has those matters been disposed?
Yes.
Matters have been disposed?
No, not yet taken, but today these matters. were
No,
fixed.
then I am anyway adjourning it. Relist after 2 weeks on a date to be fixed by the registry.
Obliged.
Same,
Same Lordship, same petition.
same order, same. Yes, Mr. Ganguly, what is this
respondents-
physical possession of secured asset?
Well, it's a very simple issue. Otherwise, a collusive suit was filed by the
Uh-huh.
landlord and tenant, and the magistrate appointed for taking physical possession said that because of the injunction passed in the landlord tenant suit, I shall not execute the physical possession order. That is why we are before your lordship. Now, before almost.
You are for the
Respondent number 3,
landlord
landlord.
and you are the
I'm the bank.
auction, you're the bank.
I'm the bank, the secured creditor.
I'm for 567.
You are the,
567.
so who is 567?
Why not if the government?
Government.
Respondent number 4.
Four. No, there is a default order of 26th March, I believe, by Justice Eddie Chaudhary. They were asked to file their replies on or before 21/4.
So replies have been filed or not?
No, nothing has been.
Any
Because-
plan to file?
Yes, Lordship. Respondent number. Respondent number.
I cannot hear anything.
Yes, respondent number 3 is under medical treatment.
All right.
He is about 79 years.
No, what do you want? If you want time for filing affidavit, this court grants. You don't have to
Yeah.
go into so much all this. You simply have to say.
Okay,
Because if you don't say it, this court cannot assume. This court, in fact, with Mr. Ganguly making a submission, this court was of the impression that perhaps this matter can be disposed of also today. So therefore, you have to speak up. You want time for
Time
filing
up-
your affidavit in
affidavit.
opposition. You also want.
Let this be the last chance. Manoj.
Mr.
D. Majumdar,
D. Majumdar, Learned Counsel, appearing for respondent number 3, right?
3.
3 submits that since the respondent number 3 is aged and is medically ill, the return could not be submitted as directed earlier by this court. However, he seeks how much time? However, he assures that the same will be filed within
After vacation.
3 weeks, 4 weeks?
4
Give me a time.
4 weeks.
But let this be listed immediately after that.
3 weeks hole vacation ho jabo. Within a period of 3 weeks from today. Similarly, Mr. M. Das. N. Das, learned counsel appearing for the state respondent, seeks time to file the return in the matter. Anybody else? You want to file something? Please give your names and with Mr. So-and-so, comma, so-and-so. Anybody else? No, just 2 of you and so-and-so. Similarly, so-and-so and so-and-so also seeks time for filing affidavit in opposition. Prayer are allowed, relists, give a date after vacation on such and such date.
Hi, Lord.
It is needless to be clarified that the returns shall be positively, and don't say that. I'm not saying that considering this person is
Last
not
chance,
well.
because that order of
It is, however, made clear that the returns shall positively be filed by the next date of mistake.
So, okay.
Yes, Mr. Chaudhary.
Lordship, my lord. Your lordship, can you see the last 2 orders, my lord? One is order dated, my lord, 29/1/25, and another is 26/5.
Kindly be passed over for the time being.
Is there any representation on behalf of?
No, that has not service
Number
complete.
8.
Nobody has come to me. The other is necessary, my lord.
Huh?
His presence is necessary, my lord.
It appears that respondent number 8, despite surveys being completed, is still not being represented in the matter. Mr. H.R.A. Chaudhary, learned senior counsel, submits that his presence otherwise would be necessary and essential in the matter. Now, we can't force someone to appear.
Yes.
Be that as it may, by way of a last chance, the matter is directed to be posted after 3 weeks on a date to be fixed by the registry, on which date, if there is no representation on behalf of respondent number 8, the matter shall be proceeded in accordance with law.
Obliged.
We can't keep waiting for someone to come. Mr.
Long
Chaudhary.
period, man, waiting. All reports are in my favor.
Yes.
Obliged.
Yes, I think Mr. Chaudhary, your matter.
Lordship,
Acha,
I'm appearing, Lordship.
All right, got them.
Lordship, give me one final opportunity, Lordship. I'll try to get in touch with the petitioner, Lordship. Otherwise, Lordship will withdraw. Only one petitioner remains, Lordship. Others have all agreed to.
Mr. N. Gautam, learned counsel for the petitioner, seeks posting of the matter after
Vacation, Your Lordship.
3 weeks to obtain the instruction as earlier called for. No? A prayer is allowed to relist after 3 weeks on a date to be fixed by the registry.
May it please allow.
Yes, Mr. Chaudhary.
My lord, this invocation of this Assam Act, my lord, it is absolutely, my lord, without any authority of law. My lord, lordship knows this Assam Act, Requisition Act, and there are judgment of our High Court. Normally, it is to be invoked for temporary purpose. Supposing, my lord, that Assam, that Act of 64, my lord, supposing there is flood, there is a war, there is some mishap happening, natural calamities, people needs to be rehabilitated. Then, my lord, even a government school can be requisition where people can be put into. If you lordship should kindly have the Assam Act for a moment, my lord. 64 Act.
Today is the first day.
Yes, motion, my lord. I'll just place 2 things, then I will come to the impugn order, my lord. Yes. Volume 2, huh? Please come to page 450, my lord.
Page
450. Section 3 of that Assam Act. Assam Land Requisition and Acquisition Act, 1964. Section 3 at page 450, my lord.
1 second. This is Assam State acquisition of Jamindari, is that not?
No, no, my lord, 450. No, oh, addition. Green এটাই ভুল।
Page 450.
Yes, my lord.
Let's
It
see.
starts at page 448.
Yes.
Please come to 450, section 3. This is what has been invoked. If in the opinion of state government or any person authorized in this behalf by the state, it is necessary so to do for maintaining supplies of services essential to the life of the community, or for providing proper facilities for accommodation, transport, communication, irrigation, flood control, and anti-erosion measures, including embankment and drainage, or for providing land individually or in group to landless, flood affected or displaced persons, or to society registered under the Assam Cooperative Societies Act, or a company incorporated under the Companies Act of 56, formed for the benefit and rehabilitation of landless, flood affected or displaced person, or to provide land for the purpose of construction of border fencing and allied work, including border road and checkpost connected therewith along Bangladesh border, state government or any persons authorized as may be, may by order in writing requisition any land, or may make such other orders as appear to him to be necessary or expedient in connection with requisition. So, my lord, very recital of section 3 makes it abundantly clear, my lord, that these are the purposes for which the power under this act can be invoked. Now, for a permanent purpose, I understand, my lord, our lands have been requisitioned there, some economic zone would be created. Now, that means you want to compulsorily acquire the land. Then why don't you invoke 2013 Act? And if you invoke 2013 Act, you have to follow a lot of procedures. Now, my lord, please come to the...
means that fair transfer.
Yes. And the judgment of that Kolkata Municipal Corporation is also there, where, my lord, 7, my lord, attributes have been laid down.
Yes.
Now, please come to this Act of 2013, my lord. Now, what they are supposed to
So
do.
what is that they have done right now?
Yes. Now, kindly come to the impugn order, my lord. These are all periodic patta land, page 67.
Are you seeking any interim to?
Yes, my lord.
What is the interim? that you
I'll
are-
pray for stay of this notification, my lord.
The
And they have not even given the procedural safeguards provided under 64 Act also. It gives 30 days time, they have given 15 days time.
Where is the?
Page 67, my lord.
Page 67.
In exercise of the power conferred on me under section 3(1) of the Assam Land Requisition and Acquisition Act, under notification dated Dispur 15th of July 93, I, Sri so-and-so, District Commissioner and Collector, Kamrup Metropolitan District, Guwahati, do hereby requisition under section 3(1) of the Assam Land Requisition and Acquisition Act, land described in the schedule below, with effect from the date of this order, for the purpose of acquisition of land for enhanced the quality and reliability of power supply to the public, as well as to support the establishment of growth of industries in and around Guwahati under Advantage Assam 2 program in village Horukhojai under Beltola Mouza. So basically they say they would like to streamline that, my lord, power supply, and secondly, to, my lord, establishment of a growth center. Now, serial number 46 is the petitioner, my lord, at page 68, Jogesh Chandra Burwa. Page 68, serial number 46. Now, end of the day, you want to acquire the land. If you want to acquire the land, then you must follow the 2013 Act, because under the Requisition Act, initially I will get a peanuts in the form of requisition compensation. Then, of course, there is a provision under section 6, whereby they can, my lord, go for acquisition also. Now, there is a caveat, my lord. Now, under Article 254, and in any case, my lord, this land acquisition is a subject in the concurrent list. So there is a central act is holding the field. Nevertheless, my lord, this act, 64 Act, here the presidential accent was there. Therefore, it will be saved under sub-article 2 of Article 254. But please come to this act, my lord, section 107. 13 Act on the action.
right?
Now here, the purpose for acquisition appears to be
Augmenting power supply and the Lord establishment of a industrial growth center under advantage Assam 2.
now, Mr. Nath, a prima facie reading of section 3 does not indicate permanent acquisition, correct? And the purposes for acquisition or requisition is given here. Now here you want to, there is no difficulty. You might need land for the growth of the advantages Assam. But would this, the manner in which you have done, whether that is correct? Because if you want to acquire it in terms of the 2013 Act, why under this?
Under 64 Act, the Deputy Commissioner has the power, he is the authority, and under section 3, the provides for power for requisition. Then
Requisition for what purpose?
Section 6 is there,
No, before we go to section 6, because if you
This
read
is a notification
section
under
3,
3.
you see, this is section 3, correct? Now, under 3(1), the purposes are given. That these are the purposes for which you will exercise the power to requisition, correct? Now, what are those purposes? You see, I am only considering prima facie right now. Otherwise, the matter has to go on there, and we are not hearing the matter today. This matter has only come for the first time, right? Now, the immediate question that is coming to the mind of this court is that where do you have this power of acquiring, requisitioning or acquiring these lands of the petitioner for the purpose of augmenting power supply and for the growth of the advantages Assam under section 3? You have to show me under section 3 that under section 3 you have the power for these purposes. Is that visualized under section 3? Because if that is not there, then anything done against the manner in which the power is given is forbidden in law. Nazir Ahmed.
Section 3 of the 64 Act, under section 3, so many land have been requisitioned.
I am not on that because your notification says section 3(1).
3(1).
Now 3(1)
is basically for the public purpose, for the urgent
where
purpose it is done.
show the reasons. Public purpose and growth of industries, they are two different things, Mr. Nath. Kindly see, let us see how it has been said.
The notice, first of all, if Lordship kindly comes to the notice,
all right.
It says
notice at page 67.
Page 67.
Yes.
Towards the middle of the notice,
yes, for the purpose.
The land described in the schedule below with effect from the date of this order for the purpose
reading
in the middle. I'm reading the entire. In exercise of powers conferred on me under section 3(1) of the Assam Land Requisition and Acquisition Act 1964, under notification number so and so dispute dated 15th of July 1993, I so and so District Commissioner and Collector Kamrup Metropolitan Guwahati do hereby requisition under section 3(1) of the Assam Land Requisition and Acquisition Act 1964, the land described in the schedule below with effect from the date of this order for the purpose of acquisition of land for enhance the quality and reliability of power supply to the public.
This says about acquisition. And you have exercised it under section 3(1).
Acquisition will come in under section 6. This is the first step.
Under but 3(1) says power of requisition.
Yes. First the requisition comes if Lordship kindly comes to section 6.
Yes. Yes.
Section 6, acquisition of land. Acquisition of land, it provides where any land has been requisitioned under section 3, the state government may use or deal with it in such manner as may appear to be expedient, and may acquire such land by publishing in the official gazette a notice to the effect.
First of all, there has to be a requisition under section 3. Only after that requisition, you may make subsequent under section 6 for acquiring.
Acquiring.
These are two different same. Now you,
Not-
under 3, you are acquiring, you have said.
No, acquisition. This is requisition, my lord.
For the purpose of acquisition.
No.
You have
And-
said under section
No,
3
hereby-
in that notification.
My lord, kindly say, I, Sri so and so district commissioner and collector, Kamrup Metropolitan District, Guwahati, do hereby requisition under section 3(1) of the Assam Land Requisition and Acquisition Act 1964.
For the purpose of acquisition.
The land described in the schedule below with effect from the date, the date of this order for the purpose of acquisition. So section 6 will come thereafter. Now the land has been requisitioned, my lord. Under section 3(1), this has been requisitioned. My lord, the purpose is, my lord, the commercial places and other residences are there. My lord, ultimately the assessment and all these things they have to do, and the acquisition is coming up, my lord. Section
See,
6 is coming up.
First and foremost, when you are exercising the power under section 3,
Logic.
the purposes are already given.
Logic.
Please impress this court that the augmentation of power supply and the growth of the industries is one of the purpose.
Well, growth of industry, the two purposes has been mentioned here, Malan. For the purpose of acquisition of the land for enhance the quality and reliability of power supply to the public, that is number 1, as well as to support the establishment and growth of industries in and around Guwahati. That is the purpose mentioned
Now,
here.
where in section 3, subsection
Well,
1,
My
these purposes are listed.
Well, my respectful submission is in section 3,
It is not.
whatever is mentioned, that is not exhaustive. The
So,
public.
in other words, in so many words, you are admitting that under section 3, these two purposes are not figuring. But you are trying to submit that reading with section 6, it has been done. This is what you are submitting, isn't it?
My respectful submission is section 3 envisages for the public purpose in the interest of public, land can be requisitioned by the authority, and that has been done. Here the purpose has been mentioned in the notification in the order. In fact, including for not only for temporary purpose but for permanent purpose also, that can be requisition, and that will be followed by section 6 and section 6. Section
Now,
7.
after this, what is to be done? What is your next step?
Well, let me give me 2 days time. Let me have the instruction. This has come for the first time. Give me 2 days time. On Friday, take up on Friday.
No, anything to be done before that?
But this has been.
What is the next step after the issuance of this notice?
But requisition has been done. Ultimately, for the purpose of acquisition, they have to go for section 6. Without acquisition, they will not go.
So you don't issue any section 6 till then.
The Millard will kindly come to page 70. Tomorrow they will enter into the land, Millard.
Section 4
Whereas the land described below has been requisitioned under says 3(1) of the Act, being the owner of or tenant in occupation, are directed to surrender or deliver possession of the requisitioned land to the collector within 15 days. That means 15 days from Millard.
Wait, Mr. Nat, I'll give you the time. But till then, you don't act on this page 70. Till then, I'm not deciding the interior matter right now. And this is qua petitioner.
Yes, qua petitioner.
What I would like to submit, Lordship may keep the matter tomorrow in the morning. These lands are.
Tomorrow morning also this whatever.
Let me have the instruction.
You have the instruction, Mr. Nath. But you are. I am making it clear that as far as section the notice at page 70 is concerned, as far as the petitioner is concerned, it should not be made effect till either tomorrow if you want or till day after. That order I am giving because. And the matter, you get your instructions because I'm hearing on the interim. I have not disposed of the interim today by granting a interim order. I am only accommodating you so that you get your chance. So you want it by tomorrow, you want it by day after tomorrow, that you decide. But you come up with your instructions because on the plain reading of section 3, it appears that the purposes which you also agree in so many words, these two are not there. However, because the interpretation which is coming to the mind of the court is that you may requisition a land. Once that land is available, thereafter you might want to acquire it for some public purpose, for which then you are going to do section 6. That could be a perception, I don't know. So you see, some application of mine would be required, and both of you have to also assist the court,
Yes,
because
definitely.
some is, this matter will need some detail, even for consideration of interim.
Well, we'll
It will
place-
need some
we'll place it.
hearing.
We'll place, Malad. Here, Lordship has seen, Malad, the land has
But
been.
since the petition, you see, Mr. Nath, the petitioner has come before the court, prima facie, he has shown. So,
Now, one more
it
thing,
doesn't
Lord,
take
it may-
anything. Anyway, when do you want it?
No, Lordship will kindly see, please come to subsection 3 of section 3. How can they give 15 days time, my lord, that they will take over possession tomorrow? Subsection 3.
Heard
When
Mr.
the-
K. N. Chaudhary, learned senior counsel, assisted by Mr. N. Chaudhary, learned counsel for the petitioner. Also heard Mr. D. Nath, learned senior government counsel, and Mr. A. Bhattacharya, learned, Bhattacharya, learned standing counsel, revenue and disaster management. I don't know about you, Mr. Chaudhary, but so many people keeps coming. I get confused with the surname sometimes, despite knowing it very well.
No, it happens.
The grievance of the petitioner canvassed in this petition under Article 226 of the Constitution of India is that the land of the petitioner is sought to be acquired on the basis of the impugned order dated
28/5, my lord.
28/5/2025, issued in LA case number 9/2025 by the District Commissioner, Kamrup Metropolitan District, for the purpose of acquisitions of land for enhance the quality and reliability of power supply to the public, as well as to the support the establishment and growth of industries in and around Guwahati under the Advantage Assam 2.0 program in village Horuhojai under Beltola, Moza. Mr. Chaudhary submits that the aforesaid notification has been issued under section 3(1) of the Assam Land Requisition and Acquisition Act 1964. However, a plain reading of section 3(1) does not envisage requisition of the subject land for the purpose mentioned in the impugned order. He further submits that though under subsection 3 of section 3 of the said act provides that when the order of requisition is made by any authority, a period of 30 days is provided for appeal to the state government against the aforesaid decision. However, the respondent authorities by page 70 document, any date is there?
Same date, my lord.
However,
28/5.
the Form C appended to the impugned order
Yes.
indicates that the land of the petitioner indicates that the petitioner has been directed to surrender or deliver possession of the
Requisition land.
subject land. Subject land, yes, he is concerned with his subject land. Stop. Mr. D. Nath, planet so-and-so, seeks a short accommodation to obtain instruction as regards the prayer of, I got like, OP, just before that you write that he accordingly seeks interim protection. Mr. Dinat, learned so-and-so, seeks a short accommodation in order to obtain instruction as regards the interim prayer made in the writ petition. In view of the aforesaid, relist on
Well, let it be on Wednesday, my lord.
I am praying for Friday, but some.
Friday?
Friday have some difficulty.
when
Next Wednesday, my
next
lord.
Wednesday. Wednesday
18th.
is 18th. Huh?
18th.
18th.
Or it can be on 17th.
Lord,
Uh,
I prefer a short time so that Lord, ultimately it's a public purpose, Lord, the
18
exercise under a particular provision of the act.
I'm not sure. 18 would, there could be difficulty.
17th or
So-
19th, my lord.
17, my Lord.
Huh?
Let
17?
it be on 17.
17.
17.
Released on 17. Huh? And then you say that, however, till the next returnable date, shall I issue notice then?
Yes.
I'll issue notice because
Lordship may keep the matter for consideration of the interim prayer. On that day, Lordship will consider.
No, till
Let
then,
me-
some
let me-
protection
let
will
me-
be, otherwise
let me
tomorrow
have
land
the-
will be taken over.
Let me have the instruction, Lord.
till the returnable date, it is made clear that the Form C issued, that the Form C appended to the impugned order dated
28/5.
28/5/2025, qua the petitioner shall not be given effect to.
Deeply.
Lordship may kindly observe, Lord, for consideration of the interim order on the next day. Although Lordship has observed.
So and so for consideration of the interim prayer.
Lord,
In that case, I think, let me issue the notice. If
Yes.
somebody wants to file, let them
yes.
file, Mr. Nath, because this court doesn't believe in keeping matters at the motion stage.
My Lord,
How many respondents are
I'm-
there? All
I'm-
are represented.
I'm accepting for 2 and 3. My friend is for 1.
You say issue notice also, huh? I'll later on edit that part. Issue notice, returnable, then it will become 1 week, right? Returnable, say
It will
what,
be on 19th, my lord.
19th. Returnable, 19 would be better. Returnable after a week. Okay? And Mr. Nath accepts notice on behalf of respondent number 1 and 2.
2 and 3.
Sorry, 2
I'm
and
for 2.
3 and 1. Mr. A. Bhattacharya for 1. Okay? For extra copies within the course of the
During
day.
the course of the year.
So if you want to file, you file it.
In the meantime.
Deeply.
And my Lord, date Lordship has given.
19th.
Yes, on 19, as the first admission matter.
My Lord.
Lordship, in 27 Lordship, service is complete.
Yeah.
However, in spite of service of notice, one is not appeared.
Hmm?
My last total Lordship, service notices are not been served on both the respondent.
Your Lordship, I'm appearing for respondent number 2.
27. You are for 2. 2. What about 1?
One Lordship notice has been served, but nobody appeared.
Heard Mr. S.C. Kayal, learned counsel of the petitioner.
BJ Das.
Mr. B.K. B.J. Das, learned counsel, enters appearance on behalf of respondent number 2. However, there is no representation on behalf of respondent number 1, despite the notice having been served. How much time you want to file your affidavit?
Lordship.
Mr. So-and-so seeks 3 weeks.
3 weeks.
3 weeks time to file return in the matter. Prayer is allowed. Relist after 3 weeks on a date to
May I
be
take
fixed
this-
by the
Another
registry.
similar matter is pending, 4144/2020.
Along, let this relist so-and-so along with
4144/2024.
WPC 4144
44.
of 2024. Yes.
So in this case, our affidavit is ready, Lordship, but some correction is required. So by Monday, we will file it.
As prayed for by MS S. Sharma,
Yes,
Learned,
PWD.
Learned Standing Council, PWD, relist, don't say as prayed, MS so-and-so submits that that though the affidavit is ready, however, due to some
Correction is.
want of correction, the same could not be filed today, and accordingly assures that the same shall be filed positively by Monday. In view of the aforesaid assurance, relist the job Friday, next Friday, on such and such date.
Right.
Same, next also same.
No.
May I please, your Lordship?
Yes,
My lord,
contractual bill.
Yes, my lord.
Yes.
Lordship, may kindly pass over this matter for the time being, madam. Is the S-board have written next?
Affidavits have been filed.
Yes, madam.
Obliged.
No, please, your Lordship, matter relating to freezer of bank account, my lord.
Yes, my lord. As per last order, my lord, we are yet to file an affidavit, my lord. They are separate.
Just 1 second. Hey,
Next week of February.
In this matter, my lord,
19th Thursday or two.
Yes, my lord.
Yes.
As per last order, we are required to file an affidavit, my lord. But next week we will file, my lord. Because, my lord, we have received an instruction.
File the affidavit or you want time to file affidavit?
We will file, my lord. Time, my lord. Because, my lord, we have received the instruction from my SP, my lord, Kasa, my lord. But he is not a party here. That is why
You were required to bring that instruction on record.
Yes, that is the.
Why? What is so difficult in bringing that instruction on record? Mr. Chetia?
Yes, my lord.
In this
Because
record,
he is not a party, my lord, from whom we have received the instruction, my lord, he is not a party in the revision. That is why some difficulty, my lord. They are saying, my lord, we will file next week. By next
the
week.
problem is that, my lord, from 2024 cases pending.
All right, let them file it.
Yes, my lord.
As prayed for, Mr. M. Chitral and State Council submits that submits with profuse apologies that the affidavit as required to be filed, placing the instruction on record could not be filed today. However, he assures that the same shall be positively filed.
And next week.
Give a date.
Any date, my lord.
By next Wednesday. Release Friday.
Yes.
Next Friday, madam. I'll always.
Mr. Chetia, listen to this. It is needless to be clarified that the said affidavit is not filed by the next date of listing. Necessary orders as required shall be passed in accordance with law.
Yes, yes.
Obliged.
31, Ms.
Please, your Lordship.
Orderly.
Matter was fixed for instruction.
Yes.
As per order dated 12.
Who's going to give instructions? Mutation, is mutation a notified subject?
Well, we had filed our affidavit of circle officer is already in a record, madam.
No, but if it's a notified subject, can an application, whether this writ petition is maintainable, if there's an alternative remedy?
Yes, your Lordship, it's a notified service. They have to apply for it. I don't know.
Well, let's see, where is the prayer? Kalijam or discourse course to heavy matter to.
Last order, please listen. Instruction of what?
Public service or order to line.
In newly inflated party. Revenue service to
Instruction from the revenue special.
revenue service.
Yes. I got the instruction. Yes, I got the instruction.
No, your instructions, 1 second, what is the prayer? To make an inquiry and pass speaking order on the representation. And the representation is for
To meet with the amendment, inquiry has been made, my lord, the circle officer affidavit is quite clear, my lord. Regarding their prayer portion, my lord.
No, what is the prayer? I have not followed. What is that they are seeking?
Meet
Page?
with
Page 9. I am in page 9, but it's a very long paragraph. The prayers must be candid. It must be very clear. Why is the prayer is so confusing? Yes. What is your prayer, Mr. Counsel?
My lordship, today matter is fixed for instruction.
Sorry?
Newly inflated party.
Oh, so if a matter is placed for instruction, you are not required to know the prayer. You don't know what the prayer is made in this petition, Mr. Counsel? Are you not the counsel for the writ petitioner? A very simple query is asked to you. You are standing before this court holding the brief.
The representation is at page 37, you know.
Yes. Page 37.
Yes.
We get situation has become different now. These days, the assistants are coming from the respondent side rather than what should have come from the petitioner side. It is your interest, your writ petition. Yes, Ms. Bodler?
It's page 37, your lordship, may kindly peruse. And 37, 38.
Then submitted the Jamabandi was not available in the revenue office
Yes.
and saying that such submitted Jamabandi can be falsely made. Mention the Jamabandi is not this kind of Jamabandi. And so. So basically mutation, application for mutation.
Page 42, your lord. Page 42 is clear.
Yes, can you read the operating part?
Operating part. Lordship, may kindly come to page 43, your lordship, point 3.
Yes.
That, sir, although I have been in continuous physical possession of the land described above, my repeated representation seeking mutation of the land in my name has not elicited any response from your office and continue to remain pending. In this connection, I may be permitted to state that my name is reflected in the Jamabandi
Very well.
surveyed
Very
village.
well. Circle officers
Yes.
affidavit?
Yes.
Filed here.
Where?
Page 52. Para 9, my lord, people also come accordingly.
Records not available.
Accordingly, a report has been submitted by the LRS on 10/7/24, wherein it is stated that the petitioner C. Bhogan Oza has submitted a Jamabandi copy of DAG number 872 of periodic Patra 73 of Korangiti map under Thokua Moja dated 27/8/34. The date mentioned in the note of the Jamabandi is 27/8/1934. And the state record is not available in the circle office.
Which is the OM where its mutation is a notified service? Please give me that. I am dismissing your writ petition because there is an alternative remedy. You can make an application before the concerned authority in the concerned form. There is an appellate authority as well as a revisional authority.
My lordship, kindly fix the matter tomorrow.
No, not tomorrow. Why tomorrow?
My senior
What will
analyst
change by tomorrow?
Not present.
The Public Service Act to change? You're going to challenge that? What will happen by tomorrow? You have an alternative efficacious remedy, avail it. Yes. এখন বিধিকা আনিব দিছিল আছে নেকি সোধকচোন I have the OM relating to the demarcation,
Yes.
but
I'm emailing it out. This is OM, this is office memorandum dated 12 April 2013. Your Lordship. This is regarding mutation.
the item of print.
Network problem, maybe. Network problem.
But government should have all these OMs because since this is the bench 4, bench 5 bench, keep the OMs specifically in relation to the Public Service Act. Or you may just, one of you, Mr. Chetia, if you can just get hold of all the OMs and give it to my court master, he'll keep it here. You please provide it. Take it to Debo, apni thoi Debo. With a copy of the act and the OMs.
Screenshot লৈ দিলে আপুনি
সেইখন বেলেগ এখন demarcation. Otherwise, you give me your mobile.
Mobile.
Hey, Bidigat Matas. কাম কৰা next matter মাতা তেতিয়ালৈকে এইখিনি উলিয়াই লওঁ Miss Bodler, you arrange for it. Let me take up the next matter because it's not fair to keep everyone waiting.
Yes.
You don't leave. I am disposing your matter. You wait. After the next matter. Mitigat Madidyo, item bus.
Lordship, matter relating to non-payment of contractors bill, Lordship.
Contractors bill, since when?
2013-14 what I
13-14.
13-14.
Yes, Mr. Upadhyay.
Lordship, affidavit is not filed, Lordship, but I have received an instruction, Lordship. They've admitted an amount of rupees 17 lakhs 13,524, Lordship. Lordship may dispose them in the line of Lordship Tomset Ali, Lordship. Serial number 18 is the Lordship, serial 18 is the petition in
Yes.
respect of the petitioner, Lordship. The
Amount is?
Lordship, the contract amount was, Lordship, 22 lakhs.
Yes.
The amount due to the petitioner is, Lordship,
17.
Lordship, column 5, Lordship,
Yes.
serial number 18.
Yes.
22 lakhs is total value, Lordship. 22 lakhs 89,861
No, no.
total value.
As per my instruction,
What
Lordship,
is due?
As per my, Lordship, can I have a look at page 19?
Wait, we'll come to your 19. Let us understand the instruction first. According to you, what
column
is the
5,
admitted?
Lordship, serial number 18. Lordship, may kindly come to the serial number 18 of column.
Yes.
It is, Lordship, amount payable to the petitioner is 20 lakhs 60,875. Amount paid to the petitioner is 3 lakhs 85,000, Lordship. Next column, Lordship.
Yes.
So now amount to be paid to the petitioner is 17 lakhs 13,524. Lordship.
So this is the admitted.
This is the admitted, Lordship.
So we shall, this court cannot go into disputed
amount.
amount.
Lordship.
If you are agreeable for a disposal, then I shall dispose this to be paid in terms of Tamsher Ali's.
Only,
Right?
only can I record that the S square page 19 is 19 lakhs.
So that we can, they will verify and it may go up.
That one may be recorded.
That is already there in the part of the
that will be always
direction of Tamsher Ali, isn't it?
that will be always there, Lord.
Heard, Mr. Huh?
NJ
NG Gogoi, na? Learned counsel for the petitioner, also heard Mr.
N. Upadhyay,
N. Upadhyay, learned counsel for the respondent. Stop.
1, 3, 4, and 5, Lordship.
Anybody else?
Finance is there for 2, Lordship.
Finance is there?
Lord,
I think please ask someone from the finance, Ms. Brodler, or you are there for finance?
His name may be recorded.
HLIA. Finance. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking release of the outstanding bill amounting to rupees 19,03,915 pending payment against the works completed by the petitioner. Stop. The brief facts of the case is that the petitioner has completed several works. No, the brief facts of the case is that pursuant to the work order dated 6/3/2015, comma, for the work restoration of existing precast celeb lining in branch canal 1, pusher capacity at LIS from River Tiloi in Hunghunglai area, PH2 under AIBP for the year 2013-14, group number Roman 6. Value of work approx so and so in reference to the technical order dated 2/3/15. You'll find it at page 5, the entire reference, comma, the petitioner completed the aforesaid work.
Page 27 is the report.
However, despite of completion of the work, there has been an outstanding amount of rupees 22,89,861 due to the petitioner.
This is the work value, Lordship.
Oh, acha.
Some amount already released.
Then outstanding amount of 19,03,915. Okay, not paid. Situated thus, the present writ petition has been filed. Mr. N. Upadhyay, Learned Counsel, so and so submits that he has received instruction
Lordship, out of the total payable amount
to
of
the effect that out of the total payable
amount
to the petitioner, I 22,
no, Lordship, it would be Lordship 20, Lordship. The work value was 20 lakh, 22 lakh, Lordship. The amount payable is
26,0875.
yes, Lordship.
An amount of rupees 3,85946 was made,
Payment was made in this.
leaving an amount of rupees 17,13524 as
Due,
due to the petitioner.
Lordship.
He further submits that in view of the aforesaid admission of the department the writ petition can be disposed of in terms of the direction passed in Tamsher Ali, so and so in the reported in so and so. This you give it later. Please
So
try and
841.
just give it the citation.
841.
Mr. So and so further submits that he submits that. Where is that 19?
Page
Which paragraph? Page?
Page 19.
Page 19.
According to page 19 of it, amount payable to the petitioner is 19.
Submits that as per the document enclosed as Annexure 3 at page 19 of the writ petition,
Serial number 3.
the amount balance due for payment admitted by the department is 19,03915 and not 17 so and so. Be that as it may, in view of the consensus arrived between the parties at the bar to dispose of the instant writ petition in terms of the direction passed in so and so, this court, in the interest of justice, deems appropriate to dispose of this matter, dispose of the instant writ petition in terms of so and so. Ordered accordingly, disposed of.
Lord.
So it is called office mutation.
Yes. Yes. There are two types of mutation.
Yes, office and field. Field is suo motu.
Yes.
Heard, Mr.
And Islam.
And Islam. And for Nagaland. And Islam Learned Counsel for the petitioner also heard,
And-
Mr.
And thus 234.
And thus Learned Counsel appearing for respondent number
234.
2, 3, and 4, and MSN Borderloy, Learned Standing Counsel, Revenue and Disaster Management for respondent number 1. Anyone else? By way of this petition under Article 2 to 6 of the Constitution of India, the petitioner is seeking direction to the respondent authorities to dispose of the representation is seeking direction to be issued to the respondent authorities to make an inquiry and pass speaking order on the representation submitted by the petitioner on 13/10/2023 before the District Commissioner Lakhimpur and 4/3/2024 to the Circle Officer Dhokwakhana Revenue Circle in connection to the prayer of the petitioner for,
Retweeting your name.
where was that page you had read, that representation which says mutation?
38 and 42.
42.
The detail.
Yes, yes, yes.
Page 43, Your Lordship, grievance statement.
Seeking mutation of the subject land of the petition. Top. The brief facts of the case is that by the order of the subdivisional magistrate, Thukwakhana, in the Chita land measuring 3 bigha, 3 katha, 13 lecha, under Dag number 872, periodic Hiraj Patta number 73, situated at village Konwar Gao, Moza, Thukwakhana, PO, Bhapara, PS, Thukwakhana, under Thukwakhana Revenue Circle, in the district of Lakhimpur, the land was mutated in the name of his father along with his uncles as per the right of inheritance. Get it at page 4, huh? However, after the death of his father on 11/5/2010, he has been in possession over the entire subject land and paying land revenue accordingly. Thereafter, thereafter the petitioner approached the circle officer, a jurisdictional circle officer, for mutating his name in the aforesaid land. However, since the said was not done, a representation was submitted before the jurisdictional district commissioner, the prayer of the petitioner seeking mutation against in respect of the subject land has not been met with. Top. Correct. Mr. Mr.
That's my
So-and-so, learned counsel for the respondent,
234.
State respondent, submits that mutation is a notified service under the Assam Right to Public Services Act 2012, and therefore the petitioner is required to submit his application for mutation as per the prescribed procedure by depositing the requisite fee. Next paragraph. The only grievance of the petitioner in the instant writ petition is that the prayer for mutation of the subject land has not been done till date. Next paragraph. The Assam Right to Public Service Act 2012, hereinafter referred to as the Act 2012, has been enacted by the state to provide for delivery of notified public service to the people of state of Assam within the stipulated time limit and for matters connected therewith and incidental thereto. Section 2H defines right to public service within quotes and in bold as right to obtain the notified service under the Act from time to time within the stipulated time limit as described under Section 5. Section 2I defines notified service within quotes and in bold as any service notified by the state government under Section 4, full stop. Section 5 of the Act 2012 further provides that every eligible person shall have the right to obtain the services in accordance with the Act within the time-bound period as notified under Section 4. Stop. It is the liability of the government servant to deliver services under Section 6 of the Act 2012, within the stipulated within the statutory period. The statutory time limit as per Section 7 within bracket 1 starts from the date when the application for obtaining a required notified service is submitted to the designated public servant or to a person subordinate to him authorized to receive the application. Such application shall be duly acknowledged upon receipt of the same. Section 7(2) further provides that the designated public servant on receipt of an application under subsection 1 shall, within the stipulated time limit, provide the notified service or reject the application, and in case of rejection of application, he shall record the reasons in writing and communicate to the person making the application. Dash, and then you say Roman 1, the reasons for such rejection, semicolon, Roman 2, the period within which an appeal against such rejection may be preferred, and Roman 3, the particulars of the appellate authority. Stop. Section 8 of the Act 2012 further provides for an appeal before the appellate authority and also for a review before the reviewing authority. By an office memorandum, next paragraph, by an office memorandum dated 12/4/2013, office memorandum bearing number RRG 12/2012/132 dated 12/4/2013 of the Government of Assam in the Revenue and Disaster Management Department, notifies, don't say notifies, declares mutation as mutation within quotes and bold, as a notified service under Section 4 of the Act 2012. The contents of the aforesaid office memorandum reads as hereunder, quote unquote. It is next. It is well settled that if there is an alternative, efficacious, and adequate remedy, then a person should avail that remedy instead of approaching this court under Article 226 of the Constitution of India. Stop. The issue involved being mere mutation as it has been projected by the petitioner. The petitioner should avail the remedy by applying for the notified public service, i.e. mutation under the Act 2012. First, by approaching the jurisdictional designated public servant, by submitting the prescribed application form, and by depositing of the requisite user charges. Upon receipt of such application, the jurisdictional designated public servant shall acknowledge the same and shall proceed to dispose of the said application as per the procedure laid down in the Act 2012. Within the stipulated time period prescribed for the said notified public service, i.e. mutation. Next para. Observed accordingly. Next, in view of the availability of the alternative and efficacious statutory remedy, the writ petition is not entertained, reserving the liberty to the petitioner to avail statutory remedy under the Act 2012 available to him under the law. The writ petition accordingly stands disposed of. Yes. Disposed of.
May I please, Your Lordship?
Yes.
But in this case, we are appearing as legal aid counsel, my lord.
Yes.
My lord, what has happened in this case, the uncle of the petitioner, my lord, he was having a fair price shop, my lord.
1 second.
In Bodibari Gaon, my lord, Rangia district.
What about the affidavits?
My lord, we have filed our affidavit.
Affidavit they have filed, my lord. Now we need to, my lord, counter because there are some.
Say so, Mr.
Vacation.
Mr. Sorry?
Vacation.
So and so learned counsel for the petitioner seeks how much time?
2 weeks.
2 weeks time to file rejoinder against the affidavit in opposition filed by respondent number 4. Prayer is allowed released after 2 weeks, 3 weeks on a date to be fixed by the registry.
My lord, no other person can, my lord, maybe given license, my lord, during pendency.
No, this you should have taken in
No,
the
already
first
given, my
date.
lord.
Anyway, next. Affidavits have been filed.
Lordship, I'm appearing on behalf of P. Sharma, Lordship. I'm appearing on behalf of
P. Sharma.
Yes.
Yes.
Standing counsel for Fishery, Lordship.
In fact, Fishery was directed for filing counter. What happened?
Yes, sir.
No, they have not filed.
They have not filed. Yes, are you planning to file?
Yes, Lordship, after a week, Lordship.
After a week?
Yes, Lordship.
Are you sure?
Yes, Lordship. Today,
If you don't file after a week, then adverse consequences will follow.
yes, Lordship.
Huh?
Yes, Lordship. Today, P. Sharma was present, but he has to rush to
No, that
hospital,
is all
Lordship.
right. You are saying weak. That's why I'm saying that whether you are saying it seriously or not.
2 weeks, my lord.
Yes.
Yes, Mr. Kotoki, that is why I was saying, because it doesn't appear that he will be in a position. Heard Mr. S. Kotoki, learned counsel for the petitioner, Mr.
R. Chetri on behalf of.
R. Chetri, on behalf of Mr. P. Sharma, learned standing counsel, Fishery Department, submits and seeks for further 2 weeks' time to file the counter affidavit. Prayer is not opposed, relist after 2 weeks on a date to be fixed by the registry.
Date may be fixed. My lord, it's a settlement on case.
Sorry?
Date may be fixed. my
No,
lord.
they will come, Mr. Kotoki, not to worry.
36, my lord, so for 36, my lord, is it a connected matter? It can be fixed after 2 weeks, my lord. R2 will file affidavit, my lord.
In case, my lord, item 34, Deputy Commissioner has filed an affidavit. They will cover the item 36 also because.
In 36, you say that Mr. M. Chetia submits that the affidavit filed by the Deputy Commissioner, within bracket respondent number, jurisdiction
Respondent
Deputy
number two.
Commissioner, respondent number 2 in WPC 647/2025 shall also cover the instant writ petition.
Yes, sir.
Relist this along with so and so on such and such day, after two, along with so and so. All right.
Look, 34 and 36.
34, not 35, right? Sorry.
34 and 36.
35 is different.
Different.
In je kolu, hetu actually WPC,
There is 36.
correct, 10 of 2025, huh? Yes, 35.
35 Lordship.
Yes, Mr. Gautam.
Seeking for enforcement of the land allocated to us.
David.
Lordship, in this case, at that time, Lordship, we have received the instructions that a process of eviction was going on, Lordship. Accordingly, we have been directed to file affidavit. We have prepared it, but yesterday, Lordship, I get that up-to-date instructions from them that notices were served upon them. Challenging those notices, they have already approached this honorable court, and there is an interim order in that case. And the case is fixed on 13th. May I pray, Lordship, let this matter be also tagged along with that one.
Is it correct?
Lordship,
This is the document, Lordship, I have.
Mr. Sharma, you keep the documents with you because despite opportunities given, you are not filing your affidavits.
That was prepared, but because of that,
You put it, whatever instructions, affidavits needs to be filed. How much time you need for putting that? Because you see on the,
yes,
March
yes, Lordship.
25,
It was prepared and sent for vetting also. But because of that up-to-date instructions,
so
Lordship,
whatever that instruction you place it
then Lordship, by that way, Lordship.
why should the affidavits not be filed? Why should the petitioners be taken by way of a surprise? You file your affidavit.
822 number. That is as because that is fixed on 13th, Lordship.
Then I'll fix this on 13.
That will be, I think,
Take this matter up on 17th or 18th, Lordship. By that time, when we can get an instruction to disregard.
Lordship.
Heard Mr. N. Gautam, learned counsel for the petitioner. Also heard Mr. H. Sharma, learned additional senior state counsel, and M. N. Bordoloi, learned standing counsel, revenue and disaster management. Mr. Sharma submits that.
The first page and second page are the notices, Lordship. And from third page, the order of this honorable court, whereby
Submits that the notice of eviction
Lordship
issued to the petitioner
on 3/6.
on 3/6/2025 has been challenged before this court in WPC 3190 of 2025. And the same is scheduled to be listed on 13/6/2025.
Lordship, if I may, Lordship. We are not the petitioners in that matter, Your Lordship.
I know, but this is related to the same thing.
Same piece of land property.
Yes,
Lordship.
today in this you are praying for what?
For allotment of the land which is
But
allocated
it appears that you have been notices for eviction has come.
against encroachers, Your Lordship.
We don't.
Yes, Lordship, against the encroachers, not against them.
Not against us, Lordship.
How is this relevant here?
As because it is relevant,
Mr. Sharma, you see here the petitioner has made a specific prayer for allotment of his land, right? Now, if there are some encroachers, that is a different issue.
no, those encroachers, Lordship, these notices were served upon those
In
encroachers.
that situation, you'll have to bring all this by way of an affidavit. Why are you not filing an affidavit?
Lordship,
File affidavit.
I'll find.
Mr. Sharma submits that how much time?
3 weeks, Lordship, as
What
because.
you said your affidavit was ready.
No,
was sent for
that is
vetting.
up to March,
Mr.
Lordship.
Sharma, please be candid in your submissions.
Lordship, I am candid, Lordship, those
You
affidavit
see,
is up to
the
March.
instruction that has now come, you are saying.
Yes,
about
Lordship,
this.
I have to
You
incorporate
put
this
you
one again.
this, You don't need 3 weeks
Lordship.
time for incorporating this. The instruction has come to you. Just edit the affidavit. Mr. So-and-so seeks further 2 weeks time to file the necessary return in the matter. Prayer is allowed. It is relist after 3 weeks on a date to be fixed by the registry. It is needless to be clarified that if the return is not filed by the next date of listing, the matter shall be proceeded in accordance with law. এইখন ঘূৰাই দিব।
Lordship.
May I please your lordship, matter relating to non-payment of outstanding contractual bill, lordship.
Affidavits.
My
Who
lord,
is appearing?
my lord, there has been standing instruction, my lord,
About what?
and page 29 is the order, speaking order. My lord, this is the writ petition, which is an offshoot of writ petition number, my lord. WPC 76/2020, my lord. And in pursuance of this order, my lord, dated 1/12/2021, my lord. Page 29, my lord, the speaking order has been passed, my lord. And it is self-explanatory, my lord. The amount is admitted, my lord, and would be paid in terms of the guidelines set in the Contractual judgment, my lord.
So it can be disposed of,
Yes, my lord.
but it says presently there is no availability of fund.
And BTC is not giving any preferential treatment to any other countries apart from the lease. It's a-
Lordship, person who have done their work later than me and whose work order after me are also, they are also received their payment, lordship.
They have to
Before
point
me,
it
lordship.
to show, my lord, in the writ petition if there is any violation on the of the Contractual judgment, my lord. Consolidated list has been prepared, my lord.
Are you agreeable for the matter to be disposed of in terms of Tamsherali?
Lordship.
Heard Mr.
At
SS, sorry, MS
At Alukdar.
A.
A
A.
Talukdar.
Talukdar, learned counsel for the petitioner, also heard Mr. SS Rabha, learned standing counsel BTC.
Yes, sir, ma'am.
Sir Rabha, standing counsel BTC.
Yes, ma'am.
Anybody else is there?
PWG attorney.
It appears that, no, sorry, by way of this writ petition under Article 226 of the Constitution of India, the writ petitioner is seeking release of the outstanding bill amount of rupees 50,41,600.00 due to the petitioner in respect of the work done by the petitioner. So, the brief facts of the case is that pursuant to a tender, the petitioner was awarded the work for construction of MT and BT road of Chakaikona to PWD road in Baksha district under AOP for the year 2016-17 by work order dated 12/9/2017. Stop. Accordingly, a contract agreement was executed, and after the work was executed and completed, the petitioner and the respondent completed to the satisfaction of the respondent authorities. The petitioner submitted the bills to the respondent authorities for payment. However, the respondent, after verification, no, don't say that. However, till today, the entire bills have not been cleared, although various representations has been submitted by the petitioner before the respondent authorities. Situated thus, the present writ petition has been filed. It appears that the respondent authorities, after verification of the work, has issued the work completion certificate against the completion of the work by the petitioner. It further appears that the this Vikas Thakuria is the same petitioner,
Yes, ma'am.
same petitioner.
Same lordship.
It further appears that
Earlier was for lordship, total amount 99 lakhs, 96,000 something lordship, but part payment was done lordship. 49 lakhs, 96,000. 922 rupees was done lordship.
no, because in your sorry, but till today the entire bill was not situated. Thus, the petitioner filed a writ petition being WPC number 76 of 2020 before this court for payment of the entire contractual bill. Stop. This court, after hearing the parties by judgment and order dated 1/12/2021, was pleased to dispose of the said petition with the direction Mr. Rabha.
Yes, my lord.
This petition cannot be disposed of because there is already a direction of this court to dispose of this case in favor, in terms of thumb share. Now you have undertaken an exercise, you have found the petitioner is verified and and you have made payments, but part payment has not been done because of non-availability of fund.
Yes.
Now the question is, within how much time this can be done? What more verification is to be done? Because if you come to the speaking order, you see, it says, whereas it may be stated, BSE conducted a comprehensive audit. As per report, the instant petitioner is found to be entitled for payment amounting to so and so. Whereas presently there is no availability of fund for disbursement of outstanding liabilities that were accrued from so and so to so and so. And therefore, in view of the above, the BTC has decided that as and when fund will be available in this regard, the payment of the instant petitioner will be made in terms of so and so.
But instead of coming with this petition, they could have filed contempt petition, my lord, if there is any violation of.
No, but if they have not filed, that doesn't mean in this writ petition, this court is going to ignore this. Now, who is going to provide the funds?
My lord, they have not also shown, my lord.
Who is going to provide the funds? Mr. Gogoi?
Finance portfolio to do.
Yes, of course.
Finance.
We are very silently sitting.
Finance is also not made party to this.
No, because there's no, I was thinking of disposing it off in terms of thumb share, but what is the use? There is already a judicial order. And after that, it appears that there was a speaking order. And as per that speaking order, they have said that made part payment amounting to so and so only against the aforesaid scheme, and the balance amount of so and so only could be made due to could not be made due to non-availability of fund. So now the only question is when this fund can be made available. Yes, Mr. Gogoi, you take notice for finance and you get us this information.
I'm not for the finance lordship.
Who is for finance?
Mr. B. Gogoi.
Oh, you are in PWD.
No, BHE.
BA. Then,
That case, my lord,
at 2, you have Mr. Gogoi here.
my lord, in that case, finance is required to be a party in the.
We shall add. Any difficulty?
No difficulty.
Then
My lord.
you do one thing. I will allow you. You file an pleading and you get finance. Because unless they are here, there will be no, nothing. Ekhini kati dia. You see, these, since I've been taking this bench, it appears that I keep getting the trap of the councils suggesting the matters can be disposed of. You have to be very careful. There's no point of disposing of this matter. Nothing is going to happen. The exercise in terms of Tamshir Ali has already been taken. Ekhini likho, kari diba. Tumi eta jagat likhiba that hurt cert kola nohoy. Tapsot the first part to likhi thoi diba. Challenge to ki korise. It further appears ei je ekhini ei matro je kolu earlier due to non-payment of so and so writ খন file korisle. Accordingly this direction to likhil na nai. Ki disla direction to for passing a speaking orders. Otherwise, it appears that pursuant to the direction of this court, by judgment and order dated 1/12/2021, passed in WPC number so and so, the BTC has verified the claims of the petitioner and passed a speaking order, which indicates that part payment amounting to rupees 49,922 has already been paid, and the remaining balance amount of rupees 50,41,600 could not be made due to non-availability of fund for the purpose non-availability of fund. Stop. It appears that the presence of the finance department is essential and necessary for the effective adjudication of the writ petition. MS so and so seeks 2 weeks time to make necessary application to implead finance department, right? Prayer is allowed, released after so and so. You file it.
Okay.
May I please, Your Lordship?
Yes.
A different intervention in this matter, my lord, as Mr. Esbota has to leave the court premises, my lord, on some medical. My lord, Mr. Esbota has to leave the court premises, my lord, due to some medical urgencies. My lord. Item 29, my lord.
It is submitted that Mr. S. Bodhakur and counsel appearing for the petitioner had to leave the court premises due to medical emergency.
Yes, ma'am.
And accordingly, an accommodation has been sought. Prayer is allowed free list after 2 weeks on a date to be fixed by the registry.
My lord.
Lordship, in this matter, we have received the instruction as well as the inquiry report, Your Lordship. So this has to come on record, Your Lordship. We need some time to file affidavit.
You want to file an affidavit?
Affidavit, Your Lordship.
Heard, Mr. R.R. Gogoi, Leonard Standing Council, Excise, submits that he has received the instructions and as well as the inquiry report, and accordingly seeks to place the same by way of an affidavit. Prayer is allowed, pre-list after 3 weeks.
Lordship, may kindly fix the date before the vacation begins. The man has been languishing without any source of income for months now. He was imprisoned.
Can you file it?
Back 2 weeks. The issue is here. We have received instruction 2 days back. Yesterday, I received an instruction from the SP, Your Lordship, stating that there are certain violations which was not before the excise department. Now,
whatever be it, you file your affidavit.
We'll file it.
Before the vacation, you file it from last week or Thursday when I did it.
Lordship, a small prayer. Lordship, in the meantime, if you would be so kind as to at least temporarily allow the man to function his shop.
No, Lord.
Yes.
Obligation.
Mr. Gogoi, make an attempt
I will.
because you've already got it.
I've got it, but I need one more instruction. I'll do it, Lord.
I'm sure you will make good use of your office.
I will, Lord.
Yes.
My pleasure, Lordship.
In this case, respondent number 5 has filed a affidavit of opposition today, my lord.
You want to file a reply?
My lord. Yes, my lord.
You want to file a reply?
Yes, my lord.
And the railway has not filed their
Yes,
affidavit.
a railway for my lord, KGO APS, my lord, he informed that my lord, instruction is added, my lord, 3 weeks time may be required.
All right. Mr. M. Chetia, learned State Council submits that affidavit on behalf of the state has been filed.
No, Union of India, my lord, KGO APS, my lord, in this case. I am not for the Union of India.
Who has filed affidavit?
Private respondent.
I see an affidavit coming up.
No, today.
Oh. It is submitted at the bar that the respondent number 5 has filed an file returned in the matter today. However, the same is not on record. Let registry verify and place the same on record. A prayer is also made on behalf of the Union of India as regards
Instruction is added.
that since prayer is made on behalf of Union of India for adjourning the case for a period of 2 weeks to enable the said respondent also to file their affidavit in opposition in the matter. Relist after 3 weeks on a date to be fixed by the registry.
Interim order passed.
Interim, if any, shall continue till the next date of listing. Yes, affidavit in opposition.
No, we are waiting instruction.
Mr. R.R. Gogoi, none appears for the petitioner on call. Mr. R.R. Gogoi, London Standing Council for Forest. Forest Department submits that instructions are awaited. Relist after 3 weeks on a date to be fixed by the registry.
Obliged. Lordship, here we received the parawise comment, Your Lordship. So there is no admission nor denial by the authorities allotted. We received the instruction. Then let the matter be verified by the Chief Engineer regarding non-payment of this contractual dues of the petitioner.
So you are for
I'm for the PHE department, Lordship.
PHE.
Yes, Your Lordship.
PHE's affidavit is neither here nor there.
Yes, the issue is here, Lordship. As per my verbal instruction, the payment has to be made by the PHE department, Your Lordship.
No, but you are PHE.
I'm PHE, Your Lordship.
So make.
So we have to verify because there is no admission from the Chief Engineer regarding the works done here.
There is no admission.
There is no admission.
Well, page number.
Only a completion certificate. They have annexed another verification. No admission by the Chief Engineers there, Lordship.
Completion certificate is sufficient.
Page 32, my lord. Top, my lord, bill verified and found correct, material as per requirement received and utilized fully for individual household latrines. The work has been completed as per approved drawings and estimate.
These are all signed and sealed.
Yes, my lord, they have signed.
Yes, why the affidavit despite final last chance, today was another chance given.
It's for taking the instructions, Your Lordship. So over a period of taking the instruction, we received the instructions.
Civil matter already disposed of, my lord, Your Lordship.
Which is that order?
Yes, my lord.
You see, this final last opportunity was given by order date 28/5/2025. Then the matter came up on 9/6/2025. Despite the final last opportunity, again, nothing was submitted.
Even my lord,
And because of the profused apologies of Mr. D. Gogoi and assurance, the matter was fixed today.
Today, Your Lordship.
Today, Mr. D. Gogoi is not there, but Mr. R.R. Gogoi is there. And now we are back to the same position.
We have received the parawise copy, received the instruction, Lordship.
What is your instruction? Give. What kind of an instruction is this, Mr. Gogoi? Huh?
There's nothing says a lordship. There's
It's very sad. Mr. Nath? What is to be done? The government officials don't respond. Contractual matters, bills are
Since 2017.
kept pending. Judicial orders are passed, giving final opportunity, nothing comes. Further final opportunity is given, still nothing comes. Now parawise, just have a look at this parawise. The documents in the writ petition are annexed where the PHA department has given complete completion certificate to the full satisfaction. Nothing is mentioned. I am aware they have their special counsels, but since you are the senior government counsel representing the state, in that capacity, this court has
Correct.
shown it to you.
Not. But executive engineer will not do this. The chief engineer or the secretary has to respond.
But that's not coming.
No, that has to come. That has to.
What is to be done? Personal appearance? Because if nobody comes, nothing is forthcoming. What is the option left with the court?
Lordship may observe, Malad. Otherwise, if Lordship may, some time may be given, Malad. Otherwise, if the secretary doesn't respond, Malad,
You see,
Lordship will observe, Malad.
on 28/5, this court says, as this matter is pending since the year 2022, a final opportunity of a week is granted. This order was of 28/5/2025. Then on 9/6/2025, this matter was placed had come up before this bench. On that day also, nothing was there. Because of the assurance of Mr. D. Gogoi, the matter was posted today. And here it was also made clear that PNRD and the other respondents are also at liberty to file affidavit instructions if they so desire. And further it is mentioned, it is needless to be clarified that if the returned instruction is not filed by the next date of listing, the matter shall be proceeded in accordance with law. Now this has come. Other departments, I don't know where they are. PW, PNRD and who is there?
As the we are not the party hearing this matter.
See, Mr. Nath, what is to be done? The litigant is before this court canvassing his non-payment of bills from the year 2017. Writ petition filed in the year 2022. The image that goes out from the court is not good, you see.
Lordship.
Once a party comes to the court, the party comes with some expectation. Yes, if there is no case, suddenly one will not get anything. But some outcome has to be delivered.
Yes.
True. Isn't it?
Correct.
We can't keep these matters hanging.
Correct.
And these are not matters which requires a full-fledged kind of a hearing also.
Order of the Honorable Court is already there.
And so many times, who is the person now who has to give this instruction?
The departmental authority, they have.
Who is the, Mr. Gogoi, who is the person? Which respondent? Yes, Mr. Counsel, which respondent?
My lord, respondent.
Yes, Mr. D. Gogoi.
My lord.
Your profuse apologies also didn't work. Your assurance last time.
Okay,
That doesn't say anything. Now, who is the concern? Who is the concern?
My lord, respondent number 2, Chief Engineer, PAC, Sanitation, Hyderabad.
He is the main person.
Yes, my lord.
All right, then I'm having it on Friday. And if Friday, no specific instruction as what is within which time frame the admitted dues can be paid, then we shall have this chief engineer present before this court at 2 o'clock.
Lordship will kindly convince you.
So it was the payment to be verified over there.
For
Lordship
Mr.
can dispose it off to the time frame.
What?
So the chief engineer will take a call.
But what is there? Nothing is there before this court.
Chief engineer can take a call, like he can verify according to Tamsher Ali.
Mr. Gohar?
My lord,
Tamsher Ali.
dispose of my lord.
See, Tamshir Ali
But
saying
if
that is
Tamsher Ali
very
comes into play, their claim is time barred.
correct. So that number one, time but number two, he may have to wait in the wait list. There are a lot of factors here. It's an admitted amount, 2017.
No,
That is
not
work.
admitted, my lord. It's just a certificate.
Page 32,
Admission has to come from the chief engineer, department chief. head.
page 32.
32, these are a bill raised by the majority endorsed by us. It is not admitted. This amounts are not
No,
admitted.
their
Signature is there, my lord.
Page 32, it says certified and found
Romania
correct.
PAC subdivision.
And
It's a
then,
subdivision bill, Your Lordship.
huh?
That's a subdivision bill.
That's a
This is
subdivision.
Subdivision bill.
See, now that is why the chief engineer
My
affidavit
lord, we'll
is
take
crucial.
it on priority basis. Lord, we'll list it in next week. We'll come with
Mr.
concrete construction.
Gogoi.
Instructions, my lord.
Do you want me? This is the third time today I'm going to read out these two orders. I have
And
already done it for Mr. R.R. Gogoi and Mr. Nath. Now I'm doing it for you again.
Lordship can.
On 28/5/2025, this court has said, as this matter is pending since the year 2022, a final opportunity of a week is granted to obtain the instruction. On 9/6/2025, you appeared before this.
My lords.
Upon Mr. D. Gogoi, Learned Standing Counsel, appearing for the PHE with profuse apologies, having assured that the affidavit and our instruction as called for earlier shall be positively filed within 2 days from today. This matter is fixed on 11/6/2025. It is needless to be clarified that if the return instruction is not filed by the next date of listing, the matter shall be proceeded in accordance with law.
My lord, this has come. This instruction your lordship peruses. There's a line there, my lord. These numbers of construction which they have carried out does not fall in the beneficiary list. It is written there. Maybe these have created a hurdle. My lord, fix it on Friday. I'll come with specific instruction of the chief engineer itself, my lord.
Mr. D. Gogoi, Learned Standing Counsel, appearing for PHE, submits that he has received para-wise instructions from the
executive engineer PHE.
From the executive engineer PHE.
My lord-
However, the same is not sufficient enough for the purpose of filing return, inasmuch as it is the chief engineer PHE who is the concerned respondent. Who is the person concerned?
My lord, the chief engineer sanitation, my lord. Respondent 2.
Yes, respondent number 2, chief engineer, public health engineer, sanitation, instruction. Who is the concerned or authority in the issue involved in this writ petition, comma, the instructions from the said, his instruction is essential.
My lord.
He accordingly submits that by Friday or Monday.
Monday will be better, my lord. I'm in a better position.
Submits that the requisite instruction from respondent number 2 shall be positively placed on Monday, so and so before this court.
My lord, I had some difficulty on Monday, my lord.
You have difficulty on Monday?
Yes, my lord.
When?
My lord, any other
Friday, next Friday? Next Friday.
Next Friday, my lord.
Then make it next Friday. And it is needless to be clarified that if the affidavits as have been directed for the last 2 consecutive dates of hearing as final opportunities for submission, if it's not filed by the next date of listing and or requisite instruction and or full requisite instruction is not placed before this court, the concerned respondent number 2 shall be personally present in the court. If you have the full instruction, this court has to be single day. But what half-hearted instruction?
Always, my lord.
Yes.
I think counsel for the.
Why is this for others?
Let it come for admission hearing after.
Why is the matter placed for orders? Both of you have not seen the office notes. There was some impediment.
Yes, implemented.
So it says the office note says no affidavit is received by the section till date.
Other side, they have not filed.
Who is, no.
Newly implemented respondent number 7 to 15. Private respondents.
So amended cost article has been given.
At that time, it was not required. I think it was not given. Now, if required, I'll have
They have already been entered here, their names. Yes, affidavit.
Lordship, we have misplaced the file, so a copy may be served to us furnished.
You have misplaced your file.
I'm for the corporation department.
So you want, what do you want?
A copy may be.
Who will give you the copy?
Lordship,
Who do you want the copy from?
from the petitioner, Lordship.
Ask him.
Yes.
If you, why don't you ask him?
Lordship.
Huh? You don't have to tell this court about all this. If you ask him, he'll give it to you. Give her a copy. How much time to complete the returns? This is a matter pending from 2018.
Lordship, 3 weeks.
Which department is this?
Corporation department, Lordship.
Since when are you practicing?
Last year, Lordship.
See, the difficulty, Mr. Nath, is because if fresh councils have been noticing this in the state departments and all, it is very crucial because you play a very important role in assisting the court to discharge judicial functions. If this is a 2018 matter, till now return is not filed. Matter misplaced, they could have easily asked. Today it is saying matter misplaced. She doesn't even know about return. Very, very sad state of affairs going on, Mr. Nath. They should be aware of what is happening. It's not her fault because she is new.
That's true. He has to be instructed.
Correct. It has submitted that the bar that the which department?
Corporation
The
department.
corporation department has misplaced the brief and accordingly seeks 2 weeks time so as to reconstruct the brief and submit the return thereof. Mr. So-and-so learned counsel for the petitioner is requested to furnish a copy of the writ petition along with the other papers, whatever, only writ petition, a copy of writ petition to MS so-and-so learned counsel appearing for the department. List after 3 weeks on a date to be fixed by the registry. Mr. Nag, you should bring this to the notice of the Advocate General. This court has been noticing. This is not the first case. In many cases, you see, they have their fresh juniors, they are being sent for taking time, and that sometimes for very, very important matters also. It is difficult. You want time, if you, for someone coming and mentioning sometime, that is understood. But to appear when you don't know anything is very difficult. This court always accommodates, even in your case, this court is always accommodating when you are not here. But they are not equipped at this stage to appear for these matters where they don't even know what is to be said, isn't it? Yes, ma'am.
May please, Your Lordship. Lordship, may kindly produce the order dated 15/5/2025, Lordship. Service not complete on respond number 9 and.
But petitioner counsel not there.
Lordship. Last occasion also they have sought for time and earlier they have not appeared.
None appears for the petitioner on call, relist on Friday in the order column with the remark for dismissal.
Okay.
Now they will appear on the next date.
Lordship, otherwise we have received the instruction.
That you
Yeah.
see what happens on Friday.
Okay.
May I please your lordship?
Yes.
Lordship, we will be taking steps during the course of the day, lordship, and in the meantime, we have to reestablish the contact with the client's lordship. Kindly allow us.
MS?
Elders.
Elders, learned counsel for the petitioner assures that the fresh steps as required in the matter shall be taken within a period of 2 days from today. Relist after 3 weeks on a date to be fixed by the registry.
Obliged, lordship.
May I please, lordship? I think already step has completed, lordship. Step already completed, I think.
Yes. 1 to 4, Mr. Hendik, Mr. Chetia, you're appearing?
Yes, madam. We have already filed affidavit also.
Anybody else is there to appear? How many respondents?
5, lordship.
Who is appearing for R5?
Nobody.
R5?
The private respondent, my lord, here notice has to my lord Sark, man.
No, but
Now he is the settlement holder.
the office note of 1/5/2025 indicates that the learned counsel, Ms. MS so-and-so has appeared and submitted the newly obtained address of R5. In view of the above, it may be discerned that the court cost title may be required to be amended. So you take, you do the necessary steps.
Yes, lordship.
Why you have not read the office note?
I have given
Have you
the,
read, Mr. Counsel?
given the name and address.
Mr. Counsel, did you read the office note today?
Lordship.
Did you read?
No, I have not done it.
Why? When matters are placed
I am
in the,
hurry, lordship.
your hurried is not the, you see, you don't say in this manner before this court.
Lordship,
This
I
is a
beg your pardon.
constitutional court.
I beg
You
your pardon.
must know how to make a submission before this court.
Lordship.
And when matters are posted in order column, they are posted for doing some specific steps.
Lordship.
Now, what is that? You need to look into the case record prior at 10:30 in the morning and find out why the odd matter has come up for orders.
Lordship.
And when the matters are called, accordingly assist the court. This is the minimum basic assistance that this court expects from the counsels. If this is not forthcoming, then very sad state of affair.
Lordship.
You are the writ petitioner. You are not even bothered.
Lordship, my
And you do the needful.
Lordship, I will do. Lordship, my humble prayer before your honor, kindly interim may be continued, Lordship.
No, I am not making any interim continuation at this stage. You don't even know what is happening. What is your name?
B. Khatlari, Lordship.
Mr. So-and-so, learned counsel appearing for the petitioner submits that in terms of the office order dated 1/5/2025, how much time you need?
1 week.
1 week, he may be given 1 week time to do the needful. Prayer is allowed, relist after so-and-so. Interim order passed earlier shall continue to the next date of listing.
Deep obliged, Lordship.
Today they file affidavit.
Why is this for orders? Service completed, Mr. Barpujari, you are appearing for the
My lord, R1, my lord.
affidavit is not filed.
My lord, affidavit has been filed today. It is on record, my lord.
Mr. R. Barpujari, learned counsel appearing for the respondent contemptor submits that affidavit, additional affidavit. Additional affidavit as directed by this court has been filed today.
Yes, it is there on record. It has been flag marked, my lord. That pink color flag. Lordship will find that pink color flag.
Pink color.
That's the affidavit, my lord. It starts from running page 28.
Have you received?
Yes, madam. I have
Complied?
received. No, Lordship. Lordship, may kindly see page number 33, Lordship. But they have stated that they require another 2 weeks time to comply the direction of this order. Direction contained in the order that is so. Page 33, Lordship.
At this stage, I'm not saying anything. I'm just posting it after 2 weeks. Let us see what happens.
And Lordship, we have pray for a date to be fixed, Lordship.
Huh?
And I'm appearing on behalf of Mr. N. Sharma.
Full stop. Mr.
D. Bhuya.
D. Bhuya, Learned Counsel, appearing on behalf of Mr. N. Sharma. 6, I'm saying you would want that time, huh? Takes 1 week time to obtain to peruse the aforesaid affidavit. Stop. It is further seen that as per the list after 2 weeks on a date to be fixed by the registry, it is needless to be clarified that on the next date of listing, Mr. R. Pujari shall also have the up-to-date status as regards the compliance in question. You have that?
Yes, only with regard to the peculiar factual metrics, my lord, it is taking some time, my lord. Everything
That's
is-
all right. I don't want to get
Yes.
into that right now. We will see. If make it 3 weeks.
It will be done.
3 weeks, if it is done very well, otherwise we'll have to hear and see whether.
Absolutely, my lord.
Highly obliged.
I'm so obliged.
26.
Yes, Miss.
Lordship, I have
Huh?
received instruction, my lord. Now payment has been made, my lord.
Payment has been made? Payment has been made?
Lordship, we were unable to take instruction. Kindly after.
No, has anybody told you that the payments have been made?
No, Lordship, we are.
The document that is being handed over to the court has been given to you? Why are you placing a document before this court which is not handed over to the other side? Miss
Lordship,
Counsel?
I'll file affidavit, my lord.
You see, if you want to file affidavit, say so.
Lordship.
I do not appreciate this passing of compliance because the petitioner, no doubt it's a contempt petition, but it is at the petitioner's instance that this contempt petition has been filed, correct?
Lordship.
So if there is a compliance, the petitioner is entitled to know what is the state of what is the nature of that compliance. So
I will
you
make the
place
request,
you
but payment
bring,
has already been made.
you file it by way of an affidavit.
Lordship.
MD Bora,
Lordship.
Learned Counsel for the respondent number 1,
and
2, and 3 submits that she has received instructions to the effect that the balance amount proposal has been sent, has already been paid to the petitioner and accordingly seeks a short accommodation to bring the same by way of an affidavit. MS so-and-so, Learned Counsel appearing for the petitioner, shall also obtain instruction in this regard. Relist after 1 week on a date to be fixed. Give a date after a week. You file it immediately.
Lordship, 2 weeks may be given.
No, what is to be filed 2 weeks? It's you have the instruction. You just have to put it by way of an affidavit. It will only 3 paragraphs. 1 paragraph of an unconditional apology. 2nd paragraph about the compliance and annex it.
Lordship.
How much time, Bora?
Lordship, I'll file.
See, the problem is that these matters are contempt matters. They're not regular writ petitions. So,
The petitioner counsel submits before my
Yes.
notice, she could not contact the person.
of course,
But she did not say that she did not receive the money. She could not contact the person.
all
I
right.
will bring it on record.
Yes, next.
Wait, your worship, my lord, I am for the petitioner here, my lord. I have need to file some rejoinder to the affidavit. I have need to file rejoinder.
Contempt.
No, my lord, in the main writ petition is also there.
You want to file a rejoinder where?
In the writ petition, my lord, there affidavit by respondent number 3 and
But what
5.
is this contempt?
Contempt, my lord, there was an interim order on 18/12/23 where they, after the interim order, they started construction of the building.
As prayed for by Mr. P.K. Roy Chaudhary, relist after 3 weeks to enable the petitioner file rejoinder. Rejoinder, you said?
My lord.
Rejoinder, the requisite rejoinder in the matter.
Interim order to continue.
Interim order, if any, shall continue till the next date of listing.
But here I am praying for 2 weeks time to find the affidavit.
My lord, here these petitioners members, their livelihood has been, my lord, suffered. Because their place was occupied by some outsider, then there is a page 17, my lord, direction is given.
Last chance, Mr. Bora.
My lord, one more time, because verification is still going on, my lord. That verification is going on, my lord. And today also, there's an instruction, the verification is going on.
Verification is no good until unless the payment is made.
My lord.
So you complete your instruction, positive instruction, it's a contempt matter.
Lord, sir.
As prayed for by Mr. S. Bora, learned counsel appearing for the sole respondent, so contempt, relist the matter after 2 weeks on a date to be fixed by the registry to enable the respondent file its reply in the matter positively. File in the matter.
My lord, it should be complaints so that, but several occasions they have not done it.
File it immediately.
My lord, here I need 3 weeks time to file my affidavit. This come for first time after the notice, my lord.
As prayed for by Mr. S. Bora, relist after 3 weeks on a date to be fixed by the registry to enable the contemner. Now, sole contemner. Sole contemner file its return in the matter.
But here I have received some instructions, no, I need some time to file the affidavit. Otherwise, my instruction says that in the last financial year, the FOC was granted and the treasury has refused the payment because the GST number of the petitioner was not updated.
Right, you place it by way of an affidavit.
Yes, yes. And this time.
As prayed for by Mr. D. Nath, learned counsel, no, don't say as prayed. Mr. D. Nath, learned senior, learned, you're appearing as
It's a contempt.
learned counsel appearing for the contemner, submits that he has received instruction and seeks 2 weeks time to place the same by way of an affidavit. Prayer is allowed, relist after
the reopening.
Relist after the vacation on a date to be fixed by the registry. After the ongoing summer vacation, it may otherwise. Yes.
May please, your lordship. My lord, in this matter, as per the office note, my lord, the respondent has been appeared, my lord, by the council. Respondent has been represented by the council, my lord.
Yes.
Yes, your lordship. Your lordship, regarding the contempt petition, your lordship, instructions are awaited. However, your lordship will be filing an IA for extension of time, your lordship.
So you file an IA or what? That is different. But in this contempt, you have received the show cause.
Yes, your lordship.
From then why the affidavit has not been filed till now?
Your lordship, as per the instructions, there's a similar contempt, your lordship, where we are seeing the instructions whereby your lordship, the liabilities here is regarding the supply, and therefore your lordship, the PTC authorities.
All right, you file your affidavit.
File affidavit, your lordship.
Let them file their affidavit. As prayed, sorry. No. As prayed for by MS
RM Barwa on behalf of Mr. P. Nayak.
SM RM MS RM
Barwa.
Barwa learned counsel appearing on behalf of Mr. P. Nayak, learned counsel appearing for the contemner, relist after 2 weeks on a date to be fixed by the registry to enable the petitioner file return in the matter. Yes. Mr. Hajorika.
Yes, sir.
Yes. Affidavits?
As per the previous order, your lordship, the opposite party was supposed to file an affidavit of opposition.
Yes, who's filing? Are
Your
you
lordship.
filing? You're not filing?
Your lordship, I am the newly implemented
Yes.
respondent number
You had
6.1.
time for filing affidavit in opposition on the last occasion.
Your lordship, I have been implemented on 26/3/2025.
Yes.
As 6.1 and 6.2.
Yes.
Your lordship, kindly go through the order. The earlier presiding court has passed an order to the petitioner to furnish the amended cost title of
They have not
They have not given the furnished to us, your lordship.
Not
It has
to
been-
you.
Yes.
It has to be given to the court.
Along with the service copy also. Your lordship.
But it has not been provided.
Huh?
It has been,
Office not clearly stated.
office not your lordship. They have not complied with the said order, your lordship. So until and unless they furnish the copy.
Why have you not taken the steps, Mr. Hajorika?
Apologies, your lordship.
Huh? And why are you not, this matter is fixed for orders? Orders or not?
Yes, yes.
Then why, I have seen you've been waiting in this court, why have you not bothered checking the office note?
I had checked the office.
Then you missed the office note in 5525.
The office note stated, your lordship, that, yeah, we have.
Huh?
Yes, your lordship, we had to.
So then it was for you to first point that out. Instead, you are asking about them to file their affidavits. Why?
Apologies, your lordship.
Very, very sad. What is going on? These are basic small things about order matters you people are not aware. Are you following what is happening, Mr. Hajorika, or not?
Yes, yes. Your lordship, they have
So
got.
how much time do you need now?
1 week's time sufficient, your lordship.
Huh?
1 week's time will be sufficient.
Mr. KJ Hajorika, Learned Counsel, appearing for the petitioner, submits that the amended cost title as required to be submitted before the registry shall be done, shall be furnished within a period of 2 days from today.
Your lordship, they may be give a direction to furnish a copy to us also. So we are going to file an affidavit after getting the copy.
Copies of the amended cost title be also furnished to the learned counsels appearing for the respondents. Released after 3 weeks on a date to be fixed by the registry. Mr. Hajorika, don't take these court proceedings so casually.
No.
You must look into the order sheets. Why matters are listed for orders. If matters are listed for admission and motion, it's another thing because you know why it has come. When it is in the order, you don't know. So you see, and what is to be done, you must immediately say without wasting the judicial time of the court.
Yes, sir.
Yes, next matter.
Your lordship, I have not received the copy of the read petition also.
All right, he'll give. And you see, Mr. Counsel, these are matters you must tell the councils. These are writ constitutional courts. Please do not bother us with all this. You tell him, he will give it to you. Why are you not giving him? You have implemented him as a party.
Yes. Your lordship,
Yes.
my name has not been shown in the cause list also.
Let registry reflect the name of Mr.
P. Chaudhary.
P. Chaudhary, Learned Counsel, appearing for the newly implemented respondent number 5.
6.1 and
6.1 and 6.2. Upar likhe diba, let copies of the amended cost title diso along with the writ petitions be furnished to the newly implemented so and so and to the newly implemented respondent, Learned Counsel appearing. Mr. Hajorika, please give it.
Yes, sir.
Any interim order is there?
Yes, Your Honor, they are availing it, your lordship.
I shall vacate it, I'm telling you. I'm going to vacate it if you take these matters so serious, so casually. Yes. Next.
Much obliged.
Item number 56.
Yes, Mr. Chaudhary.
Lordship would recollect this matter was listed on last Wednesday, Friday, isn't it?
Day before yesterday.
A day before yesterday.
Yes.
And my learned friend was directed to obtain the instructions.
My lord, I'm paying for some time to exhibit me to take instruction because we have to receive instruction from the IJL. And
From the?
From the IJL, Mizoram.
From where?
Because on 2 points.
From where?
My lord,
From where?
Mizoram. Instruction from IJL, Mizoram, my lord.
Mizoram.
Mizoram.
Mizoram is not that far.
My lord,
You have internet, you have everything nowadays.
because
Why it's not coming?
My one point is that whether the materials of
What was the interim relief that you were seeking, Mr.
Actually,
Chaudhary?
I'll just give a brief background, my lord. A
Yes.
particular contract was given to me. Now, as per the contract, I am to undertake some construction work. Now, my lord, on 5/3/2025, I submitted the, my lord,
what do we call it, the registered joint venture agreement. And on 7/4/25, I executed the main agreement. And pursuant to my lord, LOA dated 6/11/24, whereby
Isn't
I
that
was.
materials.
No.
Now, this
On-
case is relating to those.
Use of material,
use of
my
your
materials by
materials.
some other contractor.
Use of your materials.
Yes. Everything, my lord. Now, on 6/11/24.
So you were, on that date, you were insisting for status quo ante.
Yes. My lord, if my learned friend has not been able to obtain the instruction, then status quo as on today should be maintained. Let it get the instruction by 19th.
See,
My only problem is, my lord.
now I recollect.
Yes,
I have
please.
not opened the brief today, nor have I heard you. But if I'm not wrong, on the last occasion, the perception of this bench was because they were already on 2 occasions the
Two interim orders were
matters-
passed.
because the matter was heard in detail.
Yes.
And first time I think it was
By Honorable Justice Sanjay Mehta.
no, the first time the order was
Sorry, A.D. Chaudhary.
No, I'm not referring
sorry,
to
yes.
judges, but on the first occasion,
The
it was to
encashment of the bank
correct.
entity was state.
State, and on the second time, no coercive
Coercive.
state.
And despite
Now your grievance before this court is that despite all this, your materials having been used.
No, a third party has been engaged to carry out the work.
That is by
And they are,
using your
yes, and
material.
they are using the materials.
So that part I can clarify.
Yes.
That
That's
part I
all.
can clarify.
That part. That a third party, he should not be permitted to use my material and carry on the work. For two, and it is the I mean, the petition was filed long back. Neither have they filed the affidavit.
This is the writ petition.
Guarantee lose.
Oh.
Except.
My lord, without filing an inquiry on this point, my lord, we cannot feel whether this material has been used by other contractors.
So on that date when the order was passed for no coercive action, by
Yes.
that time it was already terminated.
Yes.
Yes.
You have been already terminated.
Yes. Now,
So,
if a lots of
You see, Mr. Chaudhary,
Yes.
as far as the material is concerned, yes, there
Yes.
is no difficulty for this court to clarify that.
Yes.
That your material shall not be
Utilized.
utilized.
By any third party.
However, the third party thing at this court is not because if they ultimately, if the work is stopped and you're not being able to complete it,
Yes.
they have to get it completed, right?
No, that situation hasn't arisen, my lord. Just on 7/4/2005, my lord, the EPC is signed. So I have got total time given to complete the project. 243 days, my lord. We are in month of June, first week of June.
All right, let me just quickly go through the
Yes.
last 2 orders.
Yes.
Plus 720.
720 days. Everything.
Work where anybody else. Not pleadings as say the date of filing, no work order was issued to somebody. I think suppose like people look at someone. On page 23, para 20 last.
Okay. Termination notice to. এখন termination order. সেই যিখন notice হৈছে এখন refer position লিখাঙ্গেল নাই. Just see. The notice which is annexed in the additional affidavit.
And do not work. Something.
Only check that once. And that too, that within 45 days you do it. And we did it within 15 days, sorry.
How are you trying to interpret this paragraph 9 of the last order, coercive action?
Yes. It is provided that no further coercive action be taken against the petitioner without taking leave of this court. That means, my lord, they will not take any action which will prejudice the petitioner without leave of the court. Please come to para 20 of our writ petition, my lord, what we have stated. Page 23.
Yes.
That as a consequence, the respondent number 3 issued the impugn termination order dated 5/5/25. It is stated herein that albeit the impugn termination notice is dated 5/5/25, the petitioner's office was served with a copy thereof only on 14/5. Notably, as has been stated herein above, the work for the project had been commenced immediately after issuance of the LOA prior to the signing of the contract agreement on 7/4/2005. As such, the date of issuance of termination notice, artwork for the project has progressed substantially with almost 95% being completed.
These are part of your
Pleadings.
petitions
So what I'm
already.
trying to show, my lord, on the day when we approached this honorable court, the third party right was not created. So therefore, that para 9 in that order of 27 assumes significance. Now, if your lordship will kindly come to the last, towards the bottom of the page, to the best of the knowledge of the petitioner, no contractor has been awarded the work as yet.
All right.
So it was in these premises, my lord, that that order was passed. So all that I'm saying is, kindly see, my lord, first order was passed on 19/5.
All right, that I've
Second was on
Now,
27.
the photographs are where in here?
Yes, yes. Additional affidavit.
Where is that statement in the additional affidavit?
Yes. Para 12.
Para 16. Page 336.
Or para 16, my lord.
Page 336.
336.
Para 15 and 16.
Para 15 and 16. That since then.
One second.
I'm sorry.
1 second.
I'm sorry.
I think this is the last matter.
Yes, yes.
You can go slow. Unless you have other engagement.
No, my lord.
Yes.
In fact, for me also, this is the last matter today. That since then, the said new
But
party.
Mr. Chaudhary, you are fortunate. After this, you can retire home.
Right.
This
Correct.
court cannot. Yes.
That since then, the said new party, as per the information received by the petitioner, the said party is Messrs. Triveni Construction, a company purportedly specializes in large-scale infrastructure construction having its registered office in Guwahati, has taken over the materials purchased by the petitioner for executing the work under the contract agreement and has even utilized some such material. It is reiterated herein that as per the knowledge of the petitioner, there is no written work order issued in favor of any third party for the concerned work. That the petitioner has photographic evidence to show that even after the interim order dated 27/5/25 was passed in the instant writ petition, whereby it was directed that no further coercive action be taken against the petitioner without leave of this court, Sri Binod Kumar and Harzimal Meena have surreptitiously continued work at the project site through the aforementioned third party by exclusively using materials which has been purchased by the petitioner therein. Moreover, on 5/6/25, Harzimal Meena called an official of the petitioner and instructed him to immediately remove metal rods which have been purchased and kept at the site by the petitioner. These actions of Binod Kumar and Harzimal Meena demonstrate their egregious disregard for the process of
Okay,
law.
I have read it.
Yes.
Now, this is the additional affidavit filed in the WP writ
Yes,
petition.
yes, my lord.
You want this order here or there was something else?
No,
1850.
1850, my lord.
That is the I.
Yes.
861 is for implement.
No, right now you want
As
this order of status quo ante in which case?
1850, my lord.
150.
Take one.
Heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. A. Gautam, learned counsel, appearing for the petitioner. Also heard Mr.
AK Dutt.
A.K. Datta, learned counsel, appearing for the respondent number 1, 2, and 3. By way of this interlocutory application, the petitioner is seeking, the applicant is seeking interim order of restoration of status quo ante as of the date of filing of the instant writ petition, qua the works pertaining to contract agreement number NFR/NFRC/Civil/2025-0010 dated 7/4/2025 entered into between the petitioner and the respondent number 3 herein. Therefore, thereby, full stop. Pertinent that on 9/6/2025, when the interlocutory application was moved before this court, Mr. A.K. Datta, learned counsel, appearing for the respondent
224 meter.
224, 1, 2, and 3 or 224?
224.
224. 224. Sought accommodation to obtain instruction in the said application. However, today when the matter is called, he further seeks how much time?
My lord, day after tomorrow or any day.
You said something else initially. How much time do you want?
1 week.
1 week time.
1 week time to further seeks 1 week time to obtain the aforesaid instructions. It appears that this court in the connected writ petition, i.e. WPC 2689/2025, which is filed by the writ petitioner stroke applicant, assailing the termination notice dated 5/5/2023 as regards the subject work, comma. Can I count the question? It appears. It appears. By order dated 19/5/2025, directed provided that till the next date of listing, and this court by order dated after perusing the pleadings and impugned order, was pleased to provide that till the next date of listing, the bank guarantee furnished by the petitioner in terms of the contract in question shall not be encashed. It further appears that thereafter, when the matter was listed on 27/5/2025, this court was further pleased to direct no further coercive actions to be taken against the petitioner without taking leave of this court. It is the specific contention of Mr. K. N. Chaudhary, learned senior counsel, that after the aforesaid interim order dated 27/5/2025 being passed, the respondent has unofficially engaged a third party, and the said third party, by utilizing the materials belonging to the petitioner, is working in respect of the subject contract, which was awarded to the petitioner. Stop. Paragraph 15, 16, 17. 15 to 17 you had shown from this an additional affidavit, no?
Yes, madam.
15 to 17. 15 to 17 of the additional affidavit filed by the petitioner in the writ petition, which is a date
On
on 6/2025, reads as hereunder. Reading of the aforesaid paragraph, it appears that two persons, Vinod Kumar and Harjimal Meena,
The officials of the.
They are the officials of railway, my lord.
being the railway authorities,
Yes.
being the official railway officials, na?
His respondent Vinod Kumar is R3.
Okay,
Respondent
then,
three, my
then
lord.
you say reading of the aforesaid additional paragraphs as well as the photographs enclosed in the additional affidavit, it appears that despite the order of this court to not take further coercive action against the petitioner without taking leave of the court, comma, two railway officials being respondent number 3
And one Harjimal.
and one
Harjimal
Harjimal
Meena.
Meena have continued the works at the project site through one third party by using the materials which has been purchased by the petitioner. Stop. Issue notice. I'm issuing formal notice in the issue notice. You are accepting for all.
Oh, yes.
Yes.
Mr. Swenso accepts notice on behalf of all the respondents.
Except my lord bank.
Bank.
For 1 to 4.
Higher bank is performing.
Bank is pro forma, my lord. Bank now is not.
It is submitted at the barn, that respondent number 5 being the respondent bank, his presence for the adjudication of the interlocutory application may not be required. Extra copies be served. In the interim, it is provided that status quo ante
As on
19/5/2025, qua the works being qua the subject works in qua the works being executed as subject matter of the contract agreement number 13. No, he will not provide it, because that is your final pending consideration of the interlocutory application. It is provided that ad interim order restraining the respondent number 1 to 4 herein from allowing continuation of works which are subject matter of the contract.
number we have given, my lord. Page 15 of the IA.
Dated so and so, it is 1415 at Pajaba by link so and so, it will I will just edit this part of the order while dictating. You file
My lord,
relist on such and such date.
My lord, because this project is nationally important, we have to open the route in scheduled time, my lord. In scheduled time.
You can do what you want to do with the leave of the court.
Yes.
The order was clear. No coercive steps without the leave of the court. You have a public interest, you take leave. Have you filed?
Deep knowledge.